Yes, madam. And I will mention item number 3 and 4, madam.
3 and 4.
Yes, madam. The matter may be example to them.
On the prayer of Mr. D. Learned Counsel for the respondents, and with the consent of the learned counsel to the petition.
Item
List
3,
this
madam.
3 and 4. List this matter after 4 weeks.
May I please listen? I beg to mention item number 11. Here I'm appearing on behalf of Legal Aid Council 87. So we are supposed to file condemnation application.
Yes.
So we need some time to file that.
On the prayer of Mr. G. Getzer.
Yes, sir.
T. Getzer, Learned Counsel, appearing on behalf of M.S.H. Jerem, Legal Aid Counsel. Let this matter be listed after 4 weeks, 3 weeks. In the meantime, the Legal Aid Counsel to file appropriate application for
The condemnation.
condemnation.
Obliged.
Your Lordship,
Yes.
Lordship, I beg to mention item number 6. Your Lordship, this matter may be listed after vacation.
Item number 6.
Yes, Your Lordship.
On the prayer of M.S.C. Ring.
N. Hondik. N. Hondik appearing on behalf of Titaba.
N. Hondik.
Yes, Your Lordship.
Appearing on behalf of Mr. Titaba.
Yes, Your Lordship.
And counsel to the petition. This matter after 4 weeks.
Much obliged, Your Lordship.
May Your Lordship? Your Lordship, I would like to mention item number 7.
7.
Yes, Your Lordship. Your Lordship, if possible, the matter may be listed on 1st of October. Otherwise, after Puja, Your Lordship, the senior counsel is not excused.
On the prayer of Mr.
T. Kumbo.
T. Kumbo, Learned Counsel. List this matter after Learned Counsel for the petition. List this matter after 4 weeks. 4 weeks.
After Puja. After Puja.
May my Lord, I beg to mention item number 21 on behalf of N. Ratan for the
21.
petitioner. He is out of station due to some domestic
It's
issues.
better before any other appropriate bench without me.
Much of
Your Lordship, I would like to mention item number 24.
24.
Yes.
23.
And it is, yes, it's
23.
connected with 23, item number 23. So I have sought the consent also. So the matter may be listed on 11th
If you have
November.
taken a consent, why we need to take
We have
a
no objection.
why you need to make a prayer? It's okay, you have taken consent, do whatever you want to do.
So the matter may be fixed on 11th November.
We're not fixing the date. We'll say after 6 weeks. On the joint prayer
After
of
6 weeks.
Learned Counsel for the appellants. Item 23 and 24, list this matter after 6 weeks. 6 weeks.
Since they come from Guwahati, they want a fixed date, Your Lordship.
Why? We
specific date is fixed.
list are published in advance. Okay, give the date.
11th November,
11 November.
obliged.
Your Honor, I'd like to mention item number 16.
16.
Yes, Your Honor, this matter may be taken after Puja vacation. I've taken the consent of the
We'll see. It is listed for us. We'll see.
Obliged. Your Honor, the service taken against the respondent number 2 is still awaited. Service taken against the respondent number 2 is still
We'll see.
awaited.
Therefore, we'll see. We'll pass
Gotcha.
on.
Your Lordship, I would like to mention item number 5.
Yes.
It may be listed after Puja break and the interim may continue.
On the prayer of Mr. So-and-so, Learned Counsel to the petition, list this matter after 5 weeks. Objection.
And I beg to mention BA number 91 of 2024 to be listed tomorrow for withdrawal, Your Honor.
Hmm.
With your pleasure.
May I please, Madam? I beg to mention one unlisted
call for the case diary. Scan copy of the case diary. MS L. Hage, London Additional PT, appears for the state. In the entry same 15,000, 10,000,
5,000.
bail bond of 10,000. Bail bond, you don't have to deposit cash. Same. Same order. Yes. 10,000 bail bond of 10,000. 2 sureties of like amount. The we appear within 1 week. On 4th same.
Right. Lordship here, answer record was called for loss. So it was not there in the
Where's the
record.
record?
It has not received, I think. Record is not there, Lordship. This LCR record has not, which this registry has not received LCR record, Lordship.
If the accused has been in custody for more than 150 days.
$17,900 only. This could be the reason. You were sent on 17,900. What is the offense?
Lordship, may I give a brief facts?
No. We want to see the record, that's all.
302 is there, Lordship.
Lordship, this bail is regarding NBW issue. Lordship, he was arrested.
302.
Yes, Lordship. He was arrested, then given bail, Lordship. And
Art Mr. T gets a final consent for the applicant. This court has called for the scanned copy of the trial court records. On 17/9/2024. However, the record has not been received. Mr. Accordingly, list this matter after a week. Registry to send reminder. You will send or registry?
Registry, Lordship.
Registry to send reminders.
Lordship, before vacation. On 4th.
Right.
Okay.
Lordship, we have received the WT message from the concerned IO, Lordship, that he is on the leave, Lordship, so it may be fixed after 7/10, Lordship.
7/10.
Lordship.
Yes, my lord.
You are
Yes,
on
my lord,
interim
it is appearing yesterday. But investigation officer is out of station.
yes. So
So matter will fix after 4th.
After 10, Lordship, 10/7, it is in.
if IO is out of station,
Yes, my lord.
the investigation will automatically gets halted.
No, Lordship, actually,
installed.
it should not be that, Lordship, but as per this WT message, he has taken some time, Lordship.
You are on interim bail.
Yes, my lord.
Have you appeared before the IO?
Yes, man. Yesterday, man.
You have given your statement.
No, my lord. The investigation officer is out of station, so.
Okay. Only prayer of Mr. Swenson, learned counsel for the applicant, MS L. Haggett, learned additional PP, submits them. The investigating officer, since the investigating officer is on leave, the case diary and the status report could not be produced. Therefore, press for sometime and press for listing the matter after 2 weeks.
Yes, my interim order, earlier interim order.
A prayer is allowed. List this matter after 2 weeks. Mr. Interim order was earlier shall continue.
My lord, specific date, my lord. After specific date, my lord.
Then it will be lordship after vacation only, lordship.
20, 21,
22, lordship,
22.
lordship,
October 22. Yes.
like.
Yes.
Service report upon respondent number 2 still awaited.
Award service reports for another 3 weeks. List after award service report in respect to respondent number 2 for another 3 weeks. List after 3 weeks.
Right.
What review is this?
May it pleases your lordship. The application for condonation of delay of only 52 days in preferring review, my lord.
Why review?
Review
this,
petition, my
order
lord,
of this
the,
court?
the transfer petition was dismissed, my lord. On that day, I was absent, my lord. I was not aware of the listing of the case.
Review.
Yes, my lord, review petition.
Why review?
Review, my lord, the matter was the transfer petitions filed by the FCI, my lord, was disposed of, my lord, because on that day, I was not present. And it was disposed of on merit only 1 point, and other points were not taken into account, my lord. So that is the reason we have filed the review petition.
Then you have to file an appeal. What's
And
the
if
question?
delay may be condemned, then review petition may be
What's the
heard, my lord.
question of review? There's no review, ground for review.
Transfer petition, we will have to go for SLP otherwise.
You'll have to go.
My lord,
Ground-
this IA may
just
be,
because-
IA may be
No, just because
only
you-
52 days delay, my lord. Then thereafter the review petition may be heard on
You
merit.
have the respondent.
Respondent, my lord, Mr. T. Partin is there. Yes, you are there. Mr. T. Partin is there.
Transfer petition of what?
Transfer petition of my lord, civil suits, my lord.
Civil suit. You want seeking a transfer from where to where?
One from Rowing to UPia, then another from Alo to UPia, then Tawang from UPia.
Why?
My lord, otherwise it will be difficult on our part, my lord, because we have only one document, we have to adduce evidences in all and sometimes terrain become difficult to approach, like in Alo also, my lord. And similar case is pending before
No,
the
that cannot be grounds.
similar case pending
Whatever-
before this
whatever-
honorable court,
whatever-
before the
Whatever the plaintiff, they will have the same problem
I agree.
because they are the resident of that area. So your only convenient cannot be transferred like that.
not exactly, my lord. Then one civil suit is also pending here in the UPia court, my lord.
It's all
Civil
right. It's all right.
similar questions
They
of
have their different jurisdiction. They'll have their thing because inconvenient will cause to the plaintiff again. You may be right. You have some inconvenience, and equally they are also having it. So therefore, they will to the jurisdictional court to decide. Is not it?
may I pray that may matter be taken after vacation, my lord. I will try to convince your lordship
I
regarding
don't
review
fi- I
petition.
don't find any ground for review.
My lord, first of all, IA may be allowed, then review may be taken up.
Any which they have their
Item number 14 and 15, my lord, I'm representing respondent number 1.
any objection.
We'll be filing an objection in respect of the condonation of the delay.
Condonation.
Yes, ma'am.
What to
Let them file, my lord.
heard Mr.
BK Singh, my lord.
BK Singh, learned counsel for the applicant and Mr. Why revamp for all the rest?
2 and 3.
Respondent for learned state council for
State
respondent
council,
number
Mr.
opposite
Pango is
party
appearing.
opposite party respondent number 2 and
In 94, Your Lordship, item number
24.
11, Your
2 and 3.
No, 12, 12.
2 and 3.
Yes, Your Lordship.
And Mr. T. Pertin for respondent number 1. Respondent number 1, T.
Yes, my
Pertin,
lord. T pertinent for
and
respondent.
Mr. J. Siring for
Respondent number 1 in item
Respondent
number
number
14 and 15.
item number
IA 95 and 96.
IN 95 and 96. Mr. The learned counsel for the respondents, the opposite party respondents have prayed for and granted 3 weeks time to file objection to the condemnation petition. List after 4 weeks. We'll see. But
Obliged,
I
Yes, ma'am.
thought if they don't have any objection, we'll condone the delay and dismiss your review.
Yes.
Because I don't find any ground.
Obliged.
When the service report is still awaited.
Huh?
Service report against the respondent number 2 is still awaited.
Service reports heard Mr. Learned counsel for the petitioner and Mr. Theatre Learned itself before this date. Await service report in respect of resolution number 2. This after 3 weeks.
Interim may be continued on the
Interim
interim.
order for self. Yes.
Obliged.
Here, your lordship, service is completed, your lordship. AD card returned back and service is completed. So,
17.
yes, your lordship.
Office note dated 19/09/2024 reflects that the notice upon respondent number 2 has been duly served. Therefore, service is complete. List for admission hearing
Yes, sir. After
after 4 weeks.
deeply obliged.
Obliged.
Your Honor, in this matter, the address of the respondent number 2 is changed. So, the address of the respondent number 2 is changed. So we are trying to trace out this address. So,
Mr. So-and-so, learned counsel for the petitioner
Yes, yes, your lordship. Sorry for interruption.
submits that, just wait. Submits that he may be granted some time to ascertain the address of the respondent number 2 and take fresh steps. Mr. Praise the Lord.
There is a interim order for suspension of proceeding before JMFC. And this is a case includes 302 IPC. Here you also on 21 June 2023, 24, there was direction for taking press step. And again on 14 August, within 3 days, but so far he has not taken any steps.
That's why we're granting him, because he, according to him,
So my
what is this that? What is absent? Submitted that he may be granted sometime to first ascertain the address of the respondent number 2 and 3.
yes, sir.
Two only.
Only 2 years.
Respondent number 2 and 2, and thereafter 2, and thereafter to take precise steps. Please note. the petitioner is granted for the 3 weeks time
Interim may be
to
vacated.
ascertain
No, Your Honor.
the address of the respondent number 2 and take necessary steps.
My prayer is
Take
For
necessary steps.
Your-
Just after
my prayer is
3 weeks.
for vacating the interim.
Final application will consider
Oh, less.
3 weeks. Okay. Yes.
Yes, my lord, in respect of respondent number 8, my lord, service report is still awaited.
Hmm?
In respect of respondent number 8, my lord, service report is
Await-
still awaited.
Service reports upon respondent number 8 for further 3 weeks. Just after 3
My
weeks.
lord, there is an interim order. that may-
Interim order process yes, will continue.
Much.
Where your lordship. Lordship, in IA applications, they have already filed their objections, your lordship.
Okay.
So in their objection petition, your lordship, in para 4, they have specifically mentioned that,
Yes. Saying what?
saying that they are not against all the, they have, in their, it's written in paragraph number 4, your lordship. They have specifically stated that polling booth number 3 of Tapragam and polling booth number 15,
Which one?
paragraph
by
number
whom?
4.
Election petition.
Could there be in the opposition filed by primary respondent number 1 in IA? Election petitioner.
Election petitioner has filed his objections regarding releasing of EVM, your lordship.
Yes.
So they have, in their paragraph number 4, they have stated specific statement they have made that they are against releasing of EVM of this polling booth.
Yes.
That is polling booth number 3 of Tapragam, and one is polling booth number 15 of Government Higher Secondary School. Number 2, polling booth number 11 of TCM West, lordship. So my prayer would, this can be written, but the rest may be released, your lordship,
Is it sure?
because they have,
Lordship, paragraph number 4, Lordship, with regards to paragraph number 4. Here, Lordship, election petitioner has specifically mentioned these 3 polling booths, but in the election petition, Lordship, there is since we have, in fact, we have raised certain mismatch as well as this EVMs. So may I pray that all the EVMs as well as the VVPAT of the 44 Teju ST Assembly constituency may be preserved for the proper and just adjudication of the case, Lordship. Para 4 is just the instances where we could find the mismatch, Lordship. There are still, I mean, during the course of trial, there are many things to be examined, Lordship.
They are not particular to the this particular polling booth. They have just given the instances. That's right. But they want that the EVMs and VVPATs is to be preserved. Only EVMs and VVPATs. What is the difficulty in releasing? Why you want to release?
Because still disposal of election petition that is kept in strong would be unnecessary because it, as per the statement in the objection, specifically stated, these are the.
No, he said, you read it. He said he had just given the instances where mismatch is there. But then ultimately what he said that it should be all in respect of legislative assembly.
Yes, Lordship.
For the entire constituency, it has to be preserved. That is their objection.
I leave up to the law.
Why you want that it should be released? Just because you are,
Yes, your lordship, here's the directions from Election Commission of India.
where is that?
That is in page number. Election 1, your lordship.
Next one.
Lordship.
No, number one says if the EVMs are the subject of the election petition,
Lordship.
Yes.
you cannot, you have to retain it. Isn't it? So what is to be done? Dismiss, IA dismiss.
Lordship.
I may be close. Lordship.
I can be closed, your lordship.
MS N Anju London. I heard MS N Anju London counsel for the application. And also heard Mr. A. Thakkar London counsel for the opposite party election petitioner. And Mr. D. Pang London counsel for opposite party number 2. You don't have anything to say?
No.
IA in IA, huh? By filing this IA, interlocutory application, the applicant has spread for release of electronic voting machines within bracket EVMs oblique BBPATs bracket close for further use which are kept in the strong room under the custody of district election officer Teju Lohit district in respect of 44 Teju ST Assembly constituency. It is the contention of the applicant. The opposite party, number 1, oblique election petitioner, has filed an election petition challenging the election of the respondent number 1 Respondent number one.
Yes.
Yes. Continue.
Who is there? Is respondent number two?
Respondent number 2 is one of the contesting candidates.
Yes. No, here,
Respondent number one.
IA, respondent number one. No, in IA,
Or in IA, respondent number 2.
respondent number two.
Lordship.
Respondent.
Mr. No. Respondent number two, which is pending before this. Mr. Since the election petition is pending in respect of the 44 Teju ST Assembly constituency, all the EVMs, VVPATs, in respect of the in respect of the constituency, are still kept in a strong room at Teju, as per the directives of the Election Commission of India. And as a precautionary measures, the EVMs oblique VVPATs may be required in the trial of the election petition. It is further contended that the election petition doesn't disclose any prayer for preservation, prayer to preserve the EVM public VVPATs, and doesn't disclose which may be required to be, which doesn't, what is that? Doesn't disclose for consideration of the election petition. Mr. In such event, keeping the EVMs, VVPATs in a strong room till final disposal of the election petition would be unnecessary. Therefore, phrase that the applicant prays for grant of permission allowing the applicant to take out the EVMs oblique, no, to release the EVMs oblique VVPATs of the entire constituency from the strong room of district election officer Teju. Is the EVMs oblique VV required for further and for further future use as and when required in any elections in the country. Mr. A. Tatak, learned counsel to the opposite party number 1, election petitioner. Submits that. No, not submits. While objecting to the prayer made by the applicant, submits that if the EVMs VVPATs are released from the safe custody for further use and randomization the data which are important for proper adjudication of the election petition. Maybe lost as there are certain mismatch in the casting and recording of the votes in the EVMs and VVPATs, particularly polling booth number 3, 11, 17, 3, 11, 15. Mr. Therefore, he submits the records of the documents along with the EVMs, VVPATs of this. The 44, in respect of 44 Tejo ST Assembly constituency, preserve for proper adjudication of the election petition. Mr. Where you have mentioned the mismatch and the grounds you have taken in the election petition.
It's in the lordship.
Next page.
Lordship page,
On consideration of the
52.
page 52.
Yes, sir. Yes, lordship. Roman 5, lordship. Material facts and of material facts and particulars of
I have considered the submissions and perused the records. Next paragraph. In consideration of the election on perusal of the election petition. The election petition, respondent number 1, the election petitioner, is particularly completed. At para 5, Roman 5,
Para 20, Roman 5.
para 20 within bracket, Roman 5, capital Roman, at page 52. To the effect that there are certain mismatch of the casting of votes where it shows that where the electron EVM shows the casting of vote of 909. No, sorry. As per Form C, the casting of vote have been shown as 909 votes, whereas the electronic voting machine EVM recorded 907 votes. Before that, you said pleaded inter alia. Huh? Next query. The copy of the election, the instruction
Page 30.
Oh. The election, the instruction issued by the Election Commissioner of India regarding the use of EVMs in elections inter alia provides that in case of any election where an election petition has been filed, the election petition has been filed, comma, if the EVMs are the subject of election petition, comma, the EVMs used at polling stations in the constituency concerned shall continue to be kept in the safe custody of the district election officer till such time the election petition is finally disposed of by the court. Next. Having considered the pleadings in the election petition, as well as the related relevant instruction issued by the Election Commission of India. Come on. I'm of the considered view that since the EVM would be and subject matter of the election petition, as the petitioner, the respondent number 1 oblique election petitioner could disclose the mismatch in the casting of votes in respect of certain polling booths, coupled with the instruction of the Election Commission of India, comma. Read that. Having considered, just read entire. Having considered the pleadings. Yes. You just read that. First line, having considered. Then comma, you just delete the last election, instruction of election. I deem it appropriate to no, it would not be proper to grant to release the EVMs oblique BVPATs list of next. Accordingly, the IA so and so is rejected. No. Accordingly, the continue. Accordingly, the prayer for release of the EBMs, public BBPATs, is rejected. The IA stands dismissed and disposed of.
Obliged.
Dismissed and closed. Dismissed and disposed of. That's all. Then
Lordship, please,
in
Lordship, may please to direct the authority, preserve the record.
no, you will not say. You file an application for that.
With regards to Lordship, the main petition, I have received the copy of all the WS for all the respondents.
All the respondents.
Yes, sir.
So next date, what is to be done?
Draft issue and documentation
Draft issue.
and documentation.
Why you are relaxing there? So, heard Mr. Swain's election petition. The respondents have filed their written statements. This the matter after when? On 4th? 4th or after vacation? Obviously you will say.
No, because it will require documentation also.
That's it. So we'll say we'll fix it for draft issues
And documentation.
on documentation, right?
And
As I said yesterday, let us learn together.
We have to.
We need fair, not only support, a very fair support from the
Yesterday.
learned council of the learned council for the parties. List this matter for filing of draft issues and documentation. List of. No, we'll say, we'll not say, the parties to file draft issues and documentation. Is it?
yes, Lordship.
Yes.
Then after your lordship will settle the issue, then we
This is the
subject to whatever somebody else.
yeah, this is the matter after. Well, this is the matter on.
Your lordship is sitting after.
No, wherever I may be, I'll take up. October.
October.
22nd,
25 man.
25. Okay. List on 25. Okay.
Deeply obliged.
Well, I will shorten my argument today.
Yes.
This is the corrected copy. No, Milord, the fact and all those aspects we have dealt with.
Yes.
And Milord, let me come to the merit of the case straight, Milord. And then, Milord, my second leave, I'll place some citations on the procedural error committed by the learned tribe. Milord, will come straight to paragraph page 60, the paragraph 40 of the right, where the learned trial judge has dealt with the issue number 1 first.
Oh. Paper book.
Yes, Milord. I'll not take much of the time. Milord.
60.
Page 60 of the
60.
paper book. Milord.
Yes.
Discussions and reasons thereof, Milord. Fact, Milord, both of us are aware. Milord. There's only 2-3 points I will raise in the
It
fact.
will not be Suffice that you should, both of you should only know the facts.
No, all of us.
More important is the court has to
Milord, I said all of us.
know
know
the
the fact.
facts.
No, because
You said both of us.
no, no.
Obviously, you are dealing with this since
Milord,
many years.
Milord, there is a
I'm
Tamil.
just taking up today's, I think, third time.
Milord, that Tamil pronunciation we call is tongue sleep. So tongue sleep was there. Anyway, Milord, I apologize. This court, in order to determine issues involved in this case, carefully appreciated and evaluated entire depositions of PWs, DWs, and paper exhibits available in this case record. Issue number 1, Milord, that my lord can flip back to para 15 and page 32, Milord. On maintainability, Milord. That is on the maintainability.
32.
Yes, page 32. That number of issues they have framed, Milord. Out of 29, 5 issues were framed, picked up.
1, 6, 7. Yes.
Yes. So, since the Honorable Apex Court, white order dated 02/12/2010 in civil appeal number 2010 had already set aside the plea of result kata taken by the defendant number 2, herein I find no any other ground or grounds to be discussed on maintainability of the instant suit, and therefore I find no legal impediment to hold suit is maintainable. With this, the issue number 1 stands determined in favor of the plaintiff. I have no quarrel on. The quarrel starts from para 14. Dr. Along time since this is, who examined himself as PW1, deposed that this is father late passing time on date 1984, purchased the present Switzerland measuring about 1 pura from defendant number 1, Sri Opak Ramesh, this is at the consideration of rupees 6,000, and thereafter subsequently his deceased father on dated 23/06/1986 again purchased another 30 feet of adjacent land from the defendant number 1 at the consideration of rupees 1,000. Also stated that they have purchased the suit land, constructed OBT house over the same. And
one pura and 30 feet.
Yes, 30 feet.
Is it the word litigate?
I don't know, because
Supreme Court and back and forth. Is it word litigating?
One pura is a huge land.
Huge land. One pura,
Yeah, residential is a huge land.
One
It's
pura
more than
like
5,000 square meters is there.
5,200. 5,239 square meters.
That's what I'm saying. 5,000, but then use Supreme Court, back and forth. Anyway,
Yes.
Just one.
Yes. Also stated, page 37, stated that they have purchased a suit land, constructed OBT house and also planted some trees. He, in support of his claim, exhibited sale agreement dated 29/7/1984 and dated 23/6/1986. My lord, will kindly mark these 2 particular words because I have some issues on this. And therefore, as both the independent does not deny this fact, I have no hesitation to hold that the plaintiff late Tasing Time on dated 29/7/1984 and 23/6/1986 had purchased a land measuring area of 1 pura and 30 feet respectively from the defendant number 1, Opak Ramesh is deceased. This is also, I'm not quarreling. I'm not quarreling on this.
So there's dispute.
There is no
of
dispute.
purchase.
Even, the reason is that the learned trial judge, while rendering this impugned judgment and decree, also held that there was no denial of the fact that Opak Ramesh, my father-in-law, had parted land to. That is up to paragraph 47. That is. Now, my lord, kindly come, para 41. Since it is not a case of the plaintiff and the defendant number 1,
that the defendant number 2 also had not purchased a plot of land from his father-in-law late Hodang Rome. I find no reasons to hold that the defendant number 2 also had not purchased a plot of land from his father. Now, my lord, we need not further go beyond this. Only two things, my lord. Now, what will happen is, in such a situation, my lord, because the learned trial court has held that the defendant number 2, that is the appellant here in this appeal, my lord, and the plaintiff, the respondent number 1, both of them are having a plot of land in a particular place. Now, what should the learned court below could have done is, by resorting to section 75, my lord, that is part 3 of the CPC, the incidental proceeding, which means that the court has a power to appoint a commission in order to dispute, in order to demarcate the land.
It's not in all and sundry cases.
Yes.
You cannot, as a matter of right to claim, have an incidental proceedings.
Yes.
Is not it?
So therefore, my lord,
Am I clear?
well, that is my lord's perception, because I cannot say
Not
no.
my perception, that is what the law says.
Okay. But my duty is only to bring to the notice.
Yeah.
So my lord will kindly mark that.
Yes.
Once the title is decided in favor of both, the first,
How can the title be decided in favor of the bot? It's either of the two.
no, that's why, my lord.
Also that will be amicable settlement.
Correct, my lord, that's why.
There's no question of deciding the title.
That's why
Title
the
is-
learned court below
Either
also
one-
ought to have
Either of the two.
resort to section 65 of the CPC by constituting so that both the parties are called for. Look, if this is your land, if this is my land, and the court finds cumulatively that there is no dispute that my father-in-law has gifted the land to me. And secondly, the court also, on the basis of the defendant number 1, who is the brother-in-law of defendant number 2, not denying the fact that my father has sold land to the plaintiff. So now what happens? How to resolve? Therefore, the CPC we find
How he has resolved.
yes. No, he has not resolved. The learned court below absolutely has not applied the mind to resolve it. But at the latter part, no, only in the paragraph 58 holds that the title is given in favor of a plaintiff.
That's right.
Yes. $56. Order column, my lord.
50?
67, my lord. That's 56. 67. After 56, my lord, they given to title dispute limit 1 pura.
It's okay. This
Yeah.
is
That is how he has dealt with. Now, my lord. Now in paragraph 8, what the paragraph 48, my lord.
Yes.
Paragraph 48. No, before that, my lord, yes. Well, kindly come to paragraph 45 before I proceed further. Paragraph 45, my lord.
46 is important.
Hi, yes, I'm coming.
Your defendant number 1, paragraph 44.
Yes.
The disputed land measuring 1 so and so inherited by him from his stages further, Kodang Rome. And accordingly, he being honored same so the proceeded passing time. However, he also stated in the different application given.
Because he has in paragraph 44, my lord, the defendant number 1 has clearly statement, the land adjacent to the land of the plaintiff sold by his father
However, he also
belongs to
stated
Kaliram
that
River.
land adjacent to his plot was given to the defendant number 2. That is you.
Yes, that is me.
Hmm.
So, my lord, last slide. He in cross examination further stated that he first, my lord will kindly check his cross at the position and cross at page 112 to 113. I'll come to that. Sold 1 pura of land at consideration of rupees 6,000 and then sold another 30 feet of land to Tasing Tai and also laid stone pillar on the bound. And therefore, since this testimony of the defendant number 1 is seller of the disputed land, remain unshaken in his cross-examination by defendant number 2, I have no reason to hold that he has not sold out the disputed land to the plaintiff. Now, equally, is the case, my lord, he makes a categorical deposition under saying that the land adjacent to the plaintiff is given to the defendant number 2. Now, the land, I'm told, my lord, is covered up with a jungle. Now, who is in possession of this land? Nobody knows. Therefore, there is a particular line of thinking which is the exact place of disputed land. Even the pillar has also been referred herein, but the existence of pillar is not known. Now, my lord, kindly come to para 40. Para 40. Para 40, para 45. And therefore, this court, in order to see as to whether the defendant number 1 has a right to sell out present disputed plot of land to the plaintiff or not, need to discuss evidence thus adduced by both the defendants. However, since the Honorable Apex Court has already set aside both the Kawang decisions and dated 19/12/1991 and 23/5/1993, legally, I find it not legally permissible to rely upon any evidences that was said to have come up in the Kawang proceedings and also decision there. And accordingly, this court proposes not to discuss any evidence said to have come up in the Kawang proceedings and also decision there. Now, my lord will see, my lord will kindly appreciate one thing. Even if the Apex Court judgment, my lord, have this, kindly have this for Apex Court judgment. My lord will kindly come to next page, my lord, page 2. Page 2 of this judgment, my lord. Supreme Court judgment. Where it is? I have furnished you. No. There's a separate sheet I have given.
Not annex.
No, not annex. Well, I have given it.
There's a certified copy there.
Certified copy, but that's in the record. Well, we'll come to page 2 first, straight. There is a third line after the fourth line. Accordingly, we direct that title suit number.
How about the extra paper pages? Extra pages. This is the one.
Well, one and the same.
Second
Second last page.
No, you read it from second para, third para, on consideration of the totality.
On considerations of the totality of the facts and circumstances of this case, we are of the considered view that in the interest of the case, it is imperative that all the aforementioned judgments and orders are set aside, and the matter is remitted to the Deputy Commissioner, Pasighat First Trade Court, to decide first the entire controversy between the parties. Accordingly, we direct that title suit number 41 of 2006 shall be revived, and same shall be decided afresh after considering the evidence to be adduced by the parties. Now, my lord, here the learned Frank Court has faulted for the reasons, because if the titles of 2006 is revived, all the evidences adduced therein has to be taken into consideration. This part, to my understanding, Lord, on perusal of the
That shall be
Yes,
revived.
records.
Shall be revived and the same shall be decided afresh
Afresh, my lord. Yes.
after considering the evidence to be adduced by the parties.
Yes, my lord.
It doesn't say the
No,
evidence
no, why? My
on
lord?
revival,
Madam,
the
why, madam?
evidence is already laid or evidence is on the record
It is
would
already-
also be revived. It's not
already
that. Afresh,
Afresh.
allowing you to adduce the says the consider after considering the evidence that to be adduced by the parties, that to be
To
not
be.
already adduced.
No, no, true, my lord. For the reasons that, my lord, kindly see from page number 100 to 101, up exhibit 1 to 6, my lord. These are the evidences which the learned court has taken into consideration in respect of the plaintiff. But if that is be the case, so all those were depositions, everything were recorded by the commissioner. Nothing has been recorded by the learned trial court when it was adjudicated as fresh. So therefore, meaning thereby, the German of my right of claiming the title is that 1992, Kava decisions. This has not been taken on board.
The parties would be at liberty to adduce evidence and file additional documents if any.
It was done.
That is done.
There is an
But it
evidence.
was,
My lord,
Respondent number one shall not be entitled to take the plea of res judicata.
so therefore, I am not taking the res judicata. Ground of res judicata, I am not saying.
Yes.
But it definitely have the evidentiary value. Relevancy of the fact. Now, my lord, kindly see, I don't remember, in the Evidence Act, section 41, relevancy of the fact.
If you don't remember, who else will remember?
I'm sorry. And I think BNS 35, kindly have this confirmation. Evidence Act. Well, I just
Evidence Act.
evidence, but just I give it. Yes, my lord. Relevancy of certain facts, judgments in probate, etc., jurisdiction, relevancy of that is in section 35 of the BNS. So therefore, the old act of the Evidence Act, old section 41 of the Evidence Act, read with section 35 of the Amendment Act, ought to have been taken into considerations. Therefore, my lord,
When was the judgment?
judgment was 2016.
When?
Which one?
New law will not allow. Let me go by this only.
Yes. My lord will decide, my lord. I want to just sum up my argument today.
So, see, to decide, I have to understand.
Yes, yes.
Is not it?
Yeah, grateful.
Without understanding the facts, at least.
That is the beauty of this
Yes.
profession.
Why you are referring for this?
Because that 1992 Kava decisions, my lord,
Yes.
these are relevant in fact to ascertain my claim of the right.
Supreme Court clearly said, set aside everything.
No, set
You
aside,
decide afraid,
but that was
giving you a chance to adduce evidence, filing under the.
fine, grateful, my lord, grateful, my lord.
Right.
I'll not say on this. Only thing is that as a court officer, my lord, I have to bring it to the notice of
Yes.
my lord. That's all. Because after all, my lord will decide. And
Have you not been allowed to adduce evidence? Have you not been allowed?
no, it was allowed, but this was not taken into consideration even by this judgment. My lord. Para 45. Therefore, this is a fault.
So as that. Yes, so as that.
Well, kindly
If you are submitting.
Para 45.
so as that.
Para
Yes.
45.
Yes.
And therefore, this court, in order to see as to whether the defendant number one had a right to sell out present disputed plot of land to the plaintiff or not, need to discuss the evidence adduced by both the defendants. However, my lord, kindly mark this. However, since the Honorable Apex Court has already set aside both the Kava decision dated 1912-1991 and 23-5-93, I find that not purpose of my lord putting here
Hmm.
That my lord will consider, because even my
To,
brother Pangin.
to rely upon any evidence or evidences that was said to have come up in the Kebang proceeding, also decision thereof. Not your evidence which you have led after the Supreme Court.
Yes.
You have been given, you have been given a chance to file documents,
Correct.
lead evidence, everything.
Whatever it is.
So what the evidence is led during the Kebab proceedings, that need not be looked into. That cannot be looked
cannot-
into, but fresh evidence.
No.
I mean,
Because
the
why I am saying that, since the learned court, trial court has taken cognizance of this in the form of record, reasoning here.
yes.
So therefore, the learned trial court ought to have given a thoughtful considerations, because that is the germinal of the whole.
Sir, you saw us, your evidence, you have led the evidence, any documents, any oral evidence, which you have led and which the court has not considered,
But that aspect,
that you saw us. That is,
but that is, in my deposition on,
that is, sir, your preciously, that is your submission,
yes,
is not it?
well, that
You saw us.
in my examination in chief also,
Yes.
in the form of DW2, and also the additional defense witnesses, all have stated about this Kabak decision.
So us.
Yes.
What the learned trial court has said
Correct.
is that since all these Kebab decisions have been set aside by the Honorable Supreme Court, the evidences which was led and came up
Correct.
during the Kebab proceedings shall not be taken into account.
Kabak proceeding will not be taken into account, but it has a relevancy, in fact, for the reasons that, rightly or the wrongly, even though same has been set aside by the Honorable Apex Court, but will have a relevancy in the fact for the circumstances that first from there I established my right, because I have 78, 79, I have written to the defendant number 1, saying that no, you have illegally sold the land, and also to them, the plaintiff, that you please return the money. I'll take back the money and return the money to you. And that evidence will find.
Yes.
One one nine.
And just read again. And accordingly, this court proposes not to discuss any evidence said to have came up in the Kebab proceeding and also decisions thereof. Trial court had not said the evidence led by you or the documents led by you shall not be considered. What he said is,
I'm not proposed to.
because of the setting aside of the Kebab decision by the Honorable Supreme Court, the evidences led and evidences came up during those proceedings shall not be considered, need not be considered.
Correct.
He's correct.
I have a different view, for the reasons that when I say
No, the evidences he need not to, but the evidence you led afresh during the trial, that has to be considered. Rejection is something different. The evidence which you have led, that has to be considered.
I fairly admit,
Yes.
on one count, that these two documents, the 1992 and 93 Kabak decisions,
Yes.
these judgments were not exhibited.
God.
So therefore it's, well, I cannot mislead,
Yes.
or I should not, my lord, even by a stretch of
Not at all, not at all.
Yes. So that
You should not
particular
think
part
of,
is there.
you should never think of that.
Those letters, my lord, this has come in the form of additional affidavit in this RFA. All those documents, these document evidences which I have referred to.
That was exhibited.
Exhibit. So therefore, my lord, now coming to this particular point, my lord, the learned trial court agreed at right from paragraph 48 to 54, my lord.
Yes.
He goes on the premises saying that oral and evidences was not there. I have sufficiently, my lord, adduce oral and documentary evidences. Now let us come, my lord, to para 48.
This is the evidence of the DW.
DW2, yes. We can read this, my lord. The defendant number 2, who examined himself as DW2 in evidence in chief, stated that he in the year 1975 purchased the disposed land from his deceased father-in-law, late Kodang Rome, at the considerations of ₹500. He further stated at the time of delivery or possession of the disputed land, his deceased father-in-law showed him the boundary of his purchase. This sentence marks of the oral evidence. He constructed his house over his given land in the year 1976 and stayed there till 1979. However, in cross-examination, he stated that he has not mentioned the total area of disputed land, and even he has no sale deed and money received, etc., in connection to this present disputed land. He also admitted that at a time when his deceased father-in-law shown him the land, no witness was there. He further admitted that he has no idea about the area of disputed land. He further admitted that the plaintiff is in possession of the sweet land since 1980. Therefore, upon careful considerations of this evidence of the defendant number 1, I have no hesitation to hold that the defendant has no documentary evidence in support of his claim. And also, there was no witness to oral sale agreement made between the defendant number 2 and let Kodang Rome, and therefore, I, in the absence of documentary evidence, find it difficult to hold that defendant number 2, who has not even mentioned the area of his claim land, had purchased present disputed plot of from late Kodang Rome. However, on being admitted by defendant number 1, son of Kodang Rome, I have no reasons to have different view except to hold that defendant number 2 also was given a plot of land by deceased father of the defendant number 1. So this is only because of the wife of statement, the position given by the defendant number 2's wife. That's why, my lord, if the learned trial court finds that there is no oral evidence of selling and the land being sold, now we will have to rely on the depositions. My lord will see that 14, serial number 14, depositions of Srimati Yaken Rome, page 128 to 31. 128 to 131.
128.
Correct. What is it? Read again. 135 to 1. Oh. Has it, my lord? No, 129. No, it should be. Sorry, my lord, 128.
Yes.
My lord, this is the witness on behalf of the plaintiff. 3, my lord, that after the visit, Kodang Rome had taken the deponent and her led husband to Mirbuk village and showed the deponent and her husband a plot of land and told them that he had given a portion from his plot of land located at Mirbuk village to his son-in-law. This is mother-in-law. So his son Kali Rigon for the purpose of building a dwelling house so that his daughter and son-in-law can stay there. The plot of land which was sown to be given to Sri Kali Rigon was clear at that point of time, and the rest portion was still a jungle. That 129. That thereafter, late Kodang Rome told my late husband that he has kept the rest part of the plot of land, which was a jungle then, for him in case he wants to settle at Pasig. That the deponent begged to stay that as shown by late Kodang Rome the whole portion of the land of late Kodang Rome located at Milbuk village was not given to Sri Kaliram Regon. And the disputed plot of land was definitely not shown by late Kodang Rome being gifted to Sri Kaliram Regon. So now in the cross, Milord, kindly see, please form of recording of deposition at page 130.
120.
130.
Yes.
It says serial number 6. I admit that a part of the disputed land was given to Sri Kaliram Regon and another part was given to Late Kamak. This Onyo Rome. So therefore, my lord, persist my right of claiming the disputed land. Then that Matung Jamo also. Para 47, my lord. DW3, my lord. Sri talked Tako Singh, that Sri Tako Singh Jamo stated, that is page number 163.
Yes, please.
That DW3 Sri Tako Singh Jamo, my lord, can we resume it too?
Yes.
My lord, when my turn comes, my lord, I will place in sequence, explaining everything.
How much you will, how long you will take?
No, another 20 minutes, because I will have, I'm placing this evidence part in order to complete how there is infirmity in the judgment. There are a few points, that error, miss title and possession. This I'll just make it
20 minutes.
Yeah. Basically, we were boiled down to paragraph 55 of the impugn judgment. And then now only the issue left for my contention is paragraph number 56 of the impugn judgment. Since this court, page 67, 67. Since this court finds no legality in sale agreement dated 29/7/1984 and 23/6/1986, Exhibit 2 executed in between the defendant number 1, Sri Opa Gorome, since this is, and the plaintiff at the same time, I find the present plaintiff entitled to have the title over 1 pura, which is equivalent to 5,350.92 square meters, purchase plot of the scribe in the schedule given in the suit with another 30 feet of land adjacent within the land described in the schedule. With this issue number 10 and 11 also stands answered in favor of the plaintiff. Now, basically, my lord, these two sale deeds, to my understanding, is not a registered sale deed. Now, in terms of specific relief act, if the possession of the property is to be delivered, this document has to be registered. In the absence of this particular aspect, this impugned judgment at paragraph 56, holding issue number 10 and 11 in favor of the plaintiff, the respondent in the instant application is bad in law. I'll place citations. Now, my lord, coming to my last leg of argument, my lord, just on the first part of my written argument, my lord, I'll just request, my lord, I will place the argument. Now, as I have indicated, my lord, that 29 issues were framed by the deputy commissioners, and further no issues were framed. The learned court below even specifically, when recorded in the judgment, that out of 29, he has picked up 5 issues. Now, whether law permits such procedural aspect adopted by the Honorable Court or not, well, just I'm placing this authority.
But this your written argument which you have taken?
Yeah, written argument.
Where you have mentioned?
My lord, I have mentioned here, part 1, page 1 itself. I have shared to my brother. Yeah. Here, basically, my lord, I have raised 2 grounds. One on the procedural aspect, another on the merit of the case. Merit, I have concluded with the placing of the evidence as well. Now, my lord, just give me 2 minutes so that I finish it off. Court number 1 is waiting, my lord. Court number 1 is waiting for me as well. 1 minute, part 1. My lord is kindly aware of the fact that the Civil Code of Civil Procedure 1908 is substantive and procedural law. The observance of the rules of procedure is fundamental to the course of litigations, for they provide the necessary framework for the achievement of justice between the parties. In the instant case, the learned district and session judge, while passing the impugned judgment and decree order dated 7/12/2012, passed in title suit number so and so, records prima facie discloses that there is an absolute non-compliance of Order 6, Rule 17 of the Code of Civil Procedure. Thus, it is apt to refer to paragraphs, page 7, my lord, that I have page 728 of the paperwork, wherein inter alia recorded by the learned judge that the appellant who was pro forma defendant in a title suit number 3 of 1993 was impleaded as a party to the suit. A reading into recording at para 7 of the impugned judgment and decree dated 7/12/2012, passed in title suit number so and so, prima facie shows that no amendment application was filed to implead the appellant who is pro forma defendant, nor any order was passed by the learned trial court in this regard. To fortify the argument on this count, I deem it appropriate to refer to page 74, below that I have indicated the pages below. If my lord wishes, may turn the pages below. Lines 34 of the judgment order dated 34/2007 in BSR title number so and so, wherein the trial judge have recorded that, but the deputy commissioner, instead of passing any decree, ordered the impleadment of present pro forma defendant in this suit, and as such was so impleaded. Now, court cannot, so moto, can implead anyone. On the careful examination of it, one can safely conclude that the present appellant was pro forma defendant in the entire case, and no order was passed by the learned trial court, and thus no relief can be claimed by the plaintiff whatsoever. On this proposition of law, the coordinate bench of this honorable court in the case of Gunendra Das so and so, in para 4 has held. The learned trial court has rightly held that provisions of the order 22 will apply only if a party dies during pendency of the suit. Provisions of this order, therefore, cannot be applied to a case where a party had died before the institution of the suit. In this case, plaintiff being under the bona fide impression that defendant number 4 was leaving instituted the suit, defendant number 2 to defendant number 14 are pro forma defendant, and defendant number 2 is the only principal defendant. Plaintiff has prayed for relief against the defendant number 1 and not against the other defendants. Though the Code of Civil Procedure does not recognize any party as pro forma defendant, and it recognizes only plaintiff and defendant, yet there is practice in civil code for impleading some parties as pro forma defendants against whom no relief is claimed. Pro forma defendants are impleaded as proper parties and not as necessary parties. Their presence is required for adjudication of the matter in dispute, and in case they seek to contest the suit of the plaintiff, in that even they are considered to be principal defendant or contesting defendant. It is a long-pending practice in civil court for making mention of some defendants as principal defendant and some parties as pro forma defendant. In the instant case, defendant number 4 is a pro forma defendant, which means that plaintiff did not claim any relief against him, but solicited his presence only for the purpose of passing a decree. My lord, this judgment was rendered by his lordship, late Mr. Chaudhary. It is his judgment, my lord. My lords, what has emerged from the above facts? It is the case of appellant that the learned trial court has not adhered to the objective of Order 6, Rule 17, which according to the appellant is a clear violation of the procedural rules laid down by the Indian judiciary. It is pertinent to note that the power to allow or disallow the amendment of pleading lies with the court. but non-compliance with the provisions of Order 6, Rule 17 is authorized the procedure prescribed by the law as the learned trial court without passing any appropriate order has erred in the case of appellant who was pro forma defendant as defendant in the impugned judgment and decree dated so and so has erred seriously to perverse and safeguard the rights of the parties. In the light of the aforementioned argument, it is humbly prayed that this honorable court may please to interfere with the impugned judgment and decree dated so and so passed by the learned trial judge and remand the instant case for de novo trial in accordance with law and procedure. Now, my lord, kindly see, within this, my lord, that I will place all these authorities, my lord. Within this, my lord, there is one judgment, unless.
Have you taken the defense? No.
Well, this is
before the trial court.
No, my lord, procedural aspect I can raise in the appellate court that I have mentioned in my.
It's okay.
Yeah.
I'm asking whether you have raised this.
My lord, I am not the conducting. My brother Pandit was the conducting counsel.
Or you?
No. On this particular brief was the conducting counsel in the trial.
He was there.
Yes, it's.
None of the ground are in fact, we did right from the trial court to the Supreme Court.
But then, well, it is my duty because when I prima facie discovers that this thing has happened. So anyway, my lord, I am
Yes.
placed.
So no, you have not raised all these issues
Yes.
before the trial court.
Yes. So, my lord, in this case, my lord, I am placing this. I will furnish in the paragraph. I will not read it also. You can write down. 2006 4 SCC, my lord, paragraph 385.
2006 4 SCC.
385, paragraph 14 to 16.
6-4 SCC,
Page 14, page 385.
85.
Yes, my lord. 14 to 16, my lord.
Where are 14 to 16?
Yes, my lord. Because on the proposition that no application was filed for impleading the defendant here who was a pro forma respondent in the earlier release. At least there was. And then, my lord, 2020, my lord.
That was your pro forma respondent before the Supreme Court or after the Supreme Court order?
After this, before the Supreme Court, but there has to be application because that all title
suit 12
has been revived. 2006 has been revived.
Yes.
There I was the pro forma defendant. So then, my lord, on the proposition that once the trial commences, there cannot be any application because the finding of the learned trial court is very clear that as many as 5 DWs were examined. So therefore, once the trials commence without filing the amendment application, it is not permissible under law. Well, that's 2020.
You have read a judgment of the Justice Nisitendo saying that there is no concept of performer defendant
Correct.
under the law. It's a
but no relief can be claimed.
That's what I'm saying.
Yes.
What's the question of performer and not performer?
That's my lord will decide.
Did you have a counterclaim? No.
There was a clean counterclaim. No. There's a counter. That you argue later point of time. Well, I am placing reliance on this judgment. 2020 11 SSC.
2020
11 SSC. Page 549. Para 4 to 8 on the proposition that once trials commence, no amendment application is allowed.
4 to
8.
Was there any amendment application?
There was no requirement for any amendment application.
No, that's what I'm saying.
That's what
I'm just asking. If there was no amendment application, there's no question of allowing not.
Because 2006 title suit was revived.
It's okay. It's okay.
I'll just clarify.
You are saying that.
Yes.
You are saying that. Just wait. That you are added as a performer defendant.
Correct.
Without there being any amendment petition, you have been made defendant. Right? Now you are relying a judgment where they said no amendment will be allowed once the trial is.
Because?
Once the trial began.
Yes, because all the depositions
begins.
All the records of all the depositions.
No, when there was no amendment as such, what's the question of allowing, not allowing? They have not filed any amendment.
No, here, they have made me a defendant number 2.
Yes.
Regular. That cannot be. That is not permissible in law.
Maybe that will consider.
That-
But
that
then, but then this judgment which you have relied,
Yes.
it says that to the effect that no amendments shall be allowed the moment the trial begins.
Correct.
So when they have not sought for any amendment, what is the applicability?
Then the learned trial court ought not to have made me as a.
That is another aspect that will consider
Th-
which you have
therefore-
submitted.
Therefore, there has to be an application.
So basically, first, the part 1 is that there is a violation of non-compliance of Order 6, Rule 17.
Yes.
Yes.
Yes. But then Malad will kindly come.
Next.
That one more judgment
Yes, yes.
that out of 29 issues,
Hmm.
the honorable trial judge has picked up 5, which he cannot do, Malad. That is violation of Order 14, Rule 2, Malad. I have written in my part 2 of my thing, Malad. I just place the citation on this.
Yes.
That is Order 14, Rule 2, court to pronounce judgment on all the issues, Malad. That is 2022, Malad. 7 SSAs, 644, paragraph 33, 34, and 35. 35 record finding on all the issues. You cannot do this. Well, this, I'll read this particular.
And that is on the context that once issues are framed,
Yes.
we'll have to
You have
mention all
educated
the,
besides
all
all
the.
this, which the learned trial.
Here is a case, there were 29 issues. Only 5 issues found to be relevant, then accordingly it was taken up.
That may not be correct proposition of law. What
No, the judgment which you have realized,
I'm on that.
this is on the context,
Hmm.
on the point that all the issues framed has to be answered.
Right.
Determined.
Determined. Once it is framed, because there is no alteration, because it was done by means of the consent of both the parties. Unless there is an application otherwise, seeking consent of the parties, that the court is of the considered view that out of 29, I find that 5 issues are relevant, so therefore the adjudication will be done on the 5 issues. These particular aspect has not been dealt with. So that on that judgment, Milord, that I have relied on. Now, Milord, Mir Ahmed judgment is very important, which I have noted. Milord will kindly come. Milord, kindly come from line 1, 2, 3, 4. Milord, yes. That we'll read this, Milord. Line 3 onwards. Recorded by learned trial judge, and I quote, and the deputy commissioner as such later on, after hearing the parties framed as many as 29 issues involved, wide his order dated 28/6/1996. Further, in page 75, bottom line, the learned trial judge recorded that after framing of issues, the plaintiff examined 3 PWs, and after closure of plaintiff's evidence, the defendant and pro forma defendant examined 4 DWs in totality. Similarly, in para 14, page 94-95 of the impugned judgment and decree dated 7/12/2012, passed entitled suit number so and so, passed by learned trial judge at lines 5 at page 95, recorded. And therefore, this court, out of 29 issues framed by the learned deputy commissioner, picked up following issues for determination of the suit, which are as follows. Further, in paragraph 15, the learned trial judge has only picked up 5 issues. One is, can we make it 5? Picked up 5 issues out of 29 issues, which was already framed by deputy commissioner. Thus, it is safely concluded that the learned trial court have acted towards the objective of Order 14, Rule 2, and Rule 5, and the settled position of law that once the issues stand framed by the court by consent of the parties, such issues are not to be struck off by court. On this proposition of law, my lord, may kindly allow me to place reliance on para 7 of an order dated so and so, so and so. Well, Jammu and Kashmir, my lord, it may not be binding, but I am applying the principle of law, my lord. Para 7 reproduce, I read. No doubt that courts have power under Order 14, Rule 5 of Civil Procedure Code to amend, add, delete, or strike out the issues in order to ensure.
I've read it.
Yes. So, This is one aspect. So therefore, my lord, this particular on the procedural aspect, these are my ground. My lord, coming to the prayer point. Now, since this particular sale deed executed by the plaintiff between defendant one during course of the trial, this is not a registered document. Therefore, we are conferring title on the basis of a sale deed, unregistered sale deed, title cannot be conferred. On this proposition of law, I rely 2014 for SSC page 502.
2014
for SSC page 502, my lord. Yes. Paragraph 23 that deals with the section 34 of specific relief act is a declaratory in nature. Once you prophesy holds, on the basis of this you cannot. That's my argument, my lord. Grateful, my lord. And my brother Pangil will take care of.
What is the specific relief act 19 section 34? You have not mentioned anywhere.
No, I have not mentioned, my lord. That's on the course of on the legal proposition I have argued. Whatever, my lord.
Because why I'm asking is it's important. Tomorrow you may say that I have argued this has not been taken into.
No, my lord, I will have to because my
preserve the
no, my lord. If my argument is missed out, that is supplemented by written argument. No,
Yes.
my lord. Finally, with the conclusion, what just I have made a small overview of this judgment.
Yes.
So just I concluded the to my own understanding of this judgment, my lord.
Yes.
Just I summarize, my lord will take. My overview is that the judgment in question appears to contain several errors related to finding of fact and the application of legal principles regarding title and possession in property disputes. These are, firstly, misrepresentation of title and possession. That's one aspect. The trial court's finding that the plaintiff had the title to the land is a significant error. Because when you hold that both the defendant, number two, and the plaintiff has a plot of land in the same area, then that is a manifest error. The plaintiff's claim was based on a non-registered sale deed. I am reiterating this. The court failed to recognize that the suit was not solely about possession, but was also about the declaration of title. That's one first thing, there's error in that judgment I am pointing out, my lord. Second is, my lord, the failure to address adverse possession claims, my lord. The trial court did not adequately address the defendant's claim of adverse possession, which is a critical aspect of property dispute. The absence of a clear finding on this issue undermines the judgment's validity as it leaves unresolved the question of whether the defendant's claim could negate the plaintiff's title.
You are not argued on the principle of doctrine of adverse possession.
No, but then my finding on this judgment, I'm summarizing and concluding.
So
yes.
you have to argue on that.
Yes.
If you want to, we are taking the ground.
But there is one particular paragraph in my appeal I have written that I crave the leave of this court to raise the legal questions during course of argument. It is there.
Was it allowed?
No, my lord, it is in my appeal. But anyway, my lord consideration, because whatever it is there, I am trying to present the case in this way, my lord. What I understand about the judgment, my lord.
No, I'm saying since I'm not heard you making a submission on adverse position.
Yes.
Now you are making
therefore, my lord,
just a one-line submission.
yes. This is for the reasons because the DW2. Now the appellant
Tomorrow
has categorically.
Yes, tomorrow on your one-line submission, I may not be able, this court may not be able to appreciate or consider.
It's fine, Lord. I'll finish this and then my brother reply and give me 5-10 minutes the next day. I'll give the rejoinder.
We'll finish it today. What's the?
Yeah, yes. Now, that's why the third defect in this judgment, which I have pointed out, because my lord, to be very fierce, very honestly, my lord, there was a paucity of time and I was out of country for long. So then I could not lay my hand properly on this brief. But then today I could somehow, since last night, I burned my midnight candle and tried to find out.
Since you are out of country for so many days, you should share something to us. At least the knowledge you have hopefully you have gained from the
That I'll
outside
share,
the country,
that I,
overseas.
my lord, in that particular lecture, there is a non-disclosure agreement.
What lecture?
I went to Oxford for deliverance of a lecture, which says it is a
Do
non-disclosure.
you have
agreement.
that thing?
Yes, I have.
Soft copy?
It-
Just share us. We'd like to see.
I'll share after 6 months.
What 6 months?
There is a non-disclosure agreement.
Is it?
Yeah, because they have funded me everything.
Are you on the business trip?
No, man.
Were you on business trip?
No. Well, that is the topic I tell you. The preservation of decaying customary laws and its institution in Northeast India.
Who has organized that?
There's a Department of Law.
Department of Law of UK
Yes.
Or
That
Cal-
I'll share, Milord. I'll share
or
that
Ca-
after
or-
6 months.
or California?
No, Milord. California next month, probably November, and I'm traveling.
Okay.
So, Milord, the third inconsistency that I have discovered in judgment is that inadequate considerations of documentary, because all the evidences, Milord, as adduced right from Milord DW1 to DW5, and the additional DWs were not appreciated.
Okay.
Milord, it is for the reasons, Milord, the judgment did not give sufficient weightage to the documentary evidence presented by the applicant defendant, which included affidavit filed by DWs and AWs and other relevant documents. Other relevant is that, which I pointed out, this, although Supreme Court has quashed and set aside that 1992 and 93 Kebang, that was a requirement under the law as a relevancy of the fact for adjudication of this case. Milord. That is what I pointed out, that section 41 of the Indian Evidence Act, read with now section 37 of the DNS. Because this was very much relevant and that was German to my whole case.
That you have not made this also. You have not written your also.
No,
in your written.
it's not. No, that's I'm concluding, Milord, with that conclusive finding I'm giving of my. The failure to consider these documents undermines the legal basis for the judgment and lack of thorough examination of the evidence. That's the last, Milord. Now, certain legal precedents were ignored in this judgment. The judgment appears to ignore established legal principles regarding the burden of proof in property disputes. Because if the learned trial judge have taken into considerations the fraudulent, I will say fraudulent sale deeds between the plaintiff and the defendant number one, for the reasons that has sold my land without my knowledge, and I have given the complaint.
You saw us. Have you said anything anywhere? In one line, one word. Yes, sir. Yes,
No,
sir.
with great respect, Milord. With great respect.
Since yesterday.
Since morning, I have been very clear.
Since yesterday, you have not shown any documents or any depositions which supports your submissions.
No, that's why, Milord.
That's why I'm just giving you a chance.
Yes.
Go. I mean, still, I'm ready to hear you.
That's why. The appellant, Milord, that is DW2, had a burden
See,
to
you
prove
are
the
well,
title.
you are well
which
aware.
he did.
You are well
documented.
aware. We're
Yes,
hearing a civil appeal.
Correct, Milord. So that's why, Milord, I relied on the statement of
Today you are a
DWs.
big civil lawyer. This court is presumed to be a civil judge today, not in the constitutional
It
court.
depends on the assumption of jurisdiction by their lordships. So I agree to that.
I'm giving,
I agree
I'm
to that.
giving
Milord.
giving you a time again. Just show us any documents as of now, except for one deposition by the defendant number one in affidavit. And the cross.
1, 3, and
You
4.
have not shown your deposition, your evidence at all.
No, Milord, with great respect. That's why I have said categorically, except for the certain procedural error committed by the trial court. And second part is
That I've agreed.
that
I've
yeah.
heard you.
And then what will happen
That
is
we'll consider.
the evidence as so adduced by the defense witness and
But
additional defense witness.
Since this is a civil appeal.
Yes. So
First
therefore,
appeal.
Milord, that
This court would like to know the evidence and the documents which supports your submission.
Milord, I do not find anything, that cover order, that is at page 158.
Nothing is supporting,
Yes.
except the 93(1) and 92.
Correct.
93, which has already been set aside by the Honorable Supreme Court.
Correct.
Fair enough.
91.
I'll record that.
Yeah.
All right.
No, because one has to be very fair.
Yes.
Because when you
I
are
appreciate it,
representing a
but
council,
I'll be recording it, Mr. Tara.
Yes.
That except for one documents, the deposition of the defendant number 1, Mr. Tara, learned counsel for the appellant, could not show any documents or deposition, and he has not referred any documents or deposition of the
no, that
witnesses.
that works for me.
So ask, I'm giving you a chance. I'll give you another half an hour because see, this is not you, me, and all everybody. Not lawyers in the court. We're here to deliver justice.
May I just request to simplify this sentence?
I just want you to.
On a specific query.
I want you to do more so that it may be convenient. I mean, for fair consideration.
Correct. That
is not it.
Only may I request, instead of that particular sentence, on a specific query to the learned counsel for the appellant as to whether is any records being made as part of the record in this RFA to establish the case of the petitioner, appellant. If humorously, Mr. Tara replied, it may not be possible. It is not on the record. That kindly, instead of that, because we don't, because either my brother Pangil or I, we are not counsels, my lord also had in this side. And any, remarks that comes from the lordship will have some cascading effect to the young counsels. For us, nothing. For us, what? Even we leave our routine case to brother Pangil or myself, it will have no effect. So considering the future aspect, my lord, kindly use the simplest of the simplest word, my lord, so that the balance of equity and justice is there without the peril and cost of anyone. Because after all, my lord, whether it is a written law or it is an oral traditions by narrations, the concept is humanity. Grateful.
Concept is justice.
Justice with humanity. Justice cannot go against the humanity. Without humanity, there cannot be justice, nor this court, nor this bar. So therefore, grateful. My younger will be here, whatever my brother submits. And if my lord permits me, tomorrow I'll give a 5 minutes rejoinder.
Today, why not today?
That Diganta, senior counsel Diganta sir is waiting for me this morning.
You complete that, we'll come back. We'll complete this today.
No, let me, I would not be hearing his arguments, so grateful.
Not a single deposition has been shown before Lordship, and now I will.
No, that's why he
Civil appeal is being argued like this.
He should have been.
Yes.
That's why
Exactly.
I'm indicating. I think it's not the way you should deal with the.
Of course. Because that is why I submitted written argument only on the 2 points. It was only 2 points he asked when arguing for Honorable Justice Kosing. So when I asked this, then the next day Justice Kosing was also no, this cannot be argued like this. It's a civil appeal. How is the judgment bad in bad? And all these things that my learned friends submitted, these points were never taken in the written statement, never taken in the High Court, and never taken in the Supreme Court. Now, after the Supreme Court, having considered that there's a list between me and him, returning back that you now decide afresh, allowing additional evidences, how can all these arguments even be considered? I'll just point out, my lord, what had happened. These cabal decisions were there, admittedly. Against that, no appeal was filed, and a suit was filed before the Deputy Commissioner.
Yes.
Thereafter,
91 and 92.
yes.
Yeah, okay.
Thereafter, it was transferred to the FTC at Basar. Now, FTC at Basar, there was a trial held. By judgment and decree 34/2007, decreed in my favor. The respondent here, the plaintiff. Now, against that, it filed a civil revision petition saying that since Kabang has already been held, the FTC Basar could not have taken it up being barred by a adjudicator, though that was never adjudicated, agitated in the written step. Honorable High Court said, yes, but by res judicata because the village authority is already decided. That is how it went to the Supreme Court. The Supreme Court says nothing doing, everything gone. So
You
now
are-
how can even he say that?
You are the one who has approached the Supreme Court.
Yes.
Okay, yes.
Now, once there, the Supreme Court have seen in what manner all these proceedings were going on. Set aside everything. He was a party there. And now the Supreme Court having remanded back, saying that you decide between me and him. How can he take all these objections now? And in fact, this is not factually correct also. That there was no amendment of plan and he was brought in without being, there had been an application amendment is not correct. In fact, after he made that argument, I applied for all the not certified copies of the file notings. It's not correct. If your lordship has gone through it,
Which one?
my written argument.
You
On the last occasion, he made that point. That's why I had to file a written argument only on the 2 points.
Yeah.
That is not correct. We were allowed to withdraw and we filed afresh.
The suit.
Yes.
Title suit.
Yes.
Okay. Yes.
From page 7 onwards is the file, relevant file notings. There your lordship will find in the bottom part, petition filed by, in fact, after the Supreme Court, even this is not necessary, but I'm just pointing out, this is not even correct. What he has submitted, factually also. Paragraph 7, or page 7. Suit taken up in my file, record perused, that is 3793, my lord. Hearing fixed on such and such for orders. Both the parties present and heard them. One Kaliram Ragon should be joined as defendant. In the instances, someone to be issued to along with such and such. Thereafter, your lordship will see. Petition filed by one Sri Talam Taing, that is my husband, son of such and such, praying for to aid his name as plaintiff in place of his father who died under such and such. Further, it is seen that the petition is only son of such and such, as well as higher such and such. In view of the above, Talam Taing is such and such. Seen the petition filed with the plaintiff, Dr. Talam Taing, under Order 23 Rules such and such of CPC, praying for withdrawal of the suit. There being some omission of vital points in the original such and such, these points in the plaint. Prayer allowed to withdraw the suit with permission to file fresh plaint. So that is how we file the fresh plaint. So that is incorrect, factually.
While the first plaint and the
Yes.
was notice on the parties for. Yes, then.
Let's say thereafter filed the plaint, then there has been, thereafter the proceedings has been going on. Now, there he was implicated as a party, though as a pro forma respondent by name, but ultimately contested it right up to the Supreme Court. And he was the petitioner before the Honorable High Court. So now these questions cannot be raised. He contested it and he filed a written statement contesting our claim because our claim was for declaration of title.
So what is this written statement?
I will just show. And I will just deal with whatever he has said.
Yes.
That regarding the selling not being registered, never raised. Cannot be allowed to be raised now. Cannot. The written statement is not there. Now, your lordship will see the plan starts from page 1 of the paper book. There's a judgment of the Kerala Punjab High Court saying that pro forma defendant are bound by a decision, is bound by a decision of the court. I'll place that. In any case, after the Supreme Court, how can he raise all this?
This is the.
This is the plaint.
Plaint.
Yes.
Yes, then.
Then the prayer portion, your lordship will find at page number, so many page numbers, 5.
Yes.
For declaration of title, ownership interest in favor of the plaintiff in respect of land in question, for confirmation of position of land in favor of plaintiff for the cost of the suit, for any relief, such and such, such and such. Your lordship may kindly have the schedule of the land below. Because there, an attempt has been made to confuse that it is also not disputed that the appellant has been given a plot of land. Of course, he has been given a plot of land.
Yes.
Schedule, next page, your lordship will see. East, the land of Tani Hearing, west, main road, north, land of Kaliram Ragon. We are not on this. We are in respect of the land that was sold to us. This land is still there. Kaliram Ragon lives there. Now, this plaint was contested by the pro forma defendant, my lord. Your lordship will find at page 21. This is the written statement. Denial of each and every averments in the plaint. He properly contested it.
This dependent number one,
Yes.
he died.
Yes.
He was substituted by his wife.
Now his son.
Son.
Mr. Pertin represents, but he has hardly anything to say. Defendant number one was the person who sold it to me. So, proper here at this stage, proper, but he has contested it totally. The records of the CRP unfortunately are not in the paper book, but I recall because I appear. Disputed areas exclusively belong to the proponent and his proponent totally contested it. My lord knows at that point of time, the deputy commissioners were exercised jurisdiction as district judges. Then the 45 regulation was in force. So the spirit would apply. In any case, I am submitting again, after the recognition by the Honorable Supreme Court that there's a list between the parties now, the appellant and me, there's no question of this. So now I can at last take your lordship to the depositions.
Yes.
Oh, one more thing, my lord, kindly have page 69. This is the final part of the judgment of the trial court, district judge.
69.
69. That's why the trial court is recorded as defendant number 2. Documents, last part, below, down below. Documents exhibited by the defendant number 2. This is the 2 Kabang decisions. One is an order passed by the deputy commissioner. In the next page, is an order dated 4/2/1993 passed by the deputy commissioner, who was also set aside by the Honorable Supreme Court. So these are the only documents that were exhibited. And regarding the issues being limited only to 5, your lordship will kindly see what was the issues that were framed. If your lordship may kindly revert back to page 28. The issues were like this. Yes, the lordship got it.
Yes.
Whether the case is maintainable in its present form and as per the law that has been kept. Whether the Kabang decisions of 1912 successors were agreed by the defendant, not required anymore. Change of circumstances after the Supreme Court's order. Whether the defendant was asking repeatedly for spot verification of the DL before decision of Kabang, not relevant anymore. Whether notices were issued for holding Kabang, all these things are not relevant anymore. Only the relevant was 1, 4, 6, 7, and 10, and 8, 9 were similar. All these issues we'll see from 14 onwards also, all pertains to Kabang. So in terms of Order 14, Rule 5, the learned trial court can at any stage strike of issues. That I have given in the written arguments. I saw it, your lordship. Not required. Order 5, Rule 5. Order 14, Rule 5. It's apparent.
Order
14, Rule 5(2).
Yes.
CPC.
Order 5 rule.
Order 14,
Yes.
Rule 5.
Yes. CPC.
in my book at page 142. Starts from 141. Order 14. Starts from framing of issues, court to pronounce judgment on all issues. Then the lordship may kindly come to 5. The court may at any time before passing a decree amend the issues or frame additional issues on such terms as it thinks fit and sell such amendments or additional issues as may be necessary for determining the matters in controversy between the parties shall be so made or framed. 2. The court may also at any time before passing a decree strike out any issues that appear to be wrongly framed or introduced. He has the power. And my lord has seen most of the issues are pertaining to the Kabang. So now maybe you can finally come to the depositions. PW1 starts at 109.
Just wait. You are respondent. No, it's very difficult.
If your lordship permits, I will place everything. So that your lordship can have a look at the depositions.
Yes,
I will place his deposition also.
yes.
That's why actually he should have been placing all this and making his argument on the basis of his depositions.
So yes, he should have taken to the deposition and how this
Yes.
deposition evidence has been
Yes.
dealt with by the trial court. should have
Exactly,
been- that
but
should have been the way,
this is something is not doing since many days. It was hard once before. Yesterday also lordship has seen. But I will fair and I
Anyway.
point out everything.
Anyway, yes.
Yeah.
Page
Page number 109.
9. Yes.
Where I am a medical officer.
Hmm.
The case was first filed by my father, late Tasing Tai. My father died and that's why I was replaced as plaintiff in this case, being the eldest son and higher of Tasing Tai. I filed this case against Opagrome as defendant and Sari Kaliram Ragan as former defendant. This case is for purchasing plots of land. In the year 1984, 29 July, my father purchased a plot of land. In the year 1984, 29 July, purchased a plot of land measuring about 1 pura from Sri Opagrome at a consideration of rupees 6,000. Paper Exhibit 1 is the sale deed cum agreement and Paper Exhibit 1 is the signature of my father, Tasing Taing, and Paper Exhibit 2 is the signature of the defendant, Sri Opagrome. After purchase, we took possession of the land, cleared the jungles, erected fencing, and a kacha house was erected on the land. Again, another plot of land around 30 feet adjacent to my previous land was also purchased from Opagrome on 23/6/86 at a consideration of rupees 1,000 only. Such and such, deed cum agreement of my father is the signature of the seller such and such. Before purchase, we ascertained from both Opagrome and other people of the nearby area in respect of this, if the plot of land was encumbered or not. When we came to know that the plots of lands were free from any encumbrance, as such, we purchased the same. The boundary of the plot of land was shown by Sri Opagrome. The boundary of the plan of the land is east by Sri Tani Iring, by west by main road, north by land of Kaliram Ragan. We are accepting that he has a land there. And by south road. By the end of 1991, there was no problem from any side. We planted trees, bamboo, bushes, etc. on the land. In the last part of 1991, I got a summon from Kabang in respect of some disputes between Sri Opagrome and Sri Kaliram Ragan. I was called to attend the Kabang because I purchased the land. During I was transferred to Dapur in 89 and my father was at the time suffering from cancer. I returned here in the year 1983. During my absence, a kacha house was erected on my land and Sri Toning Pertin started living therein. Sri Sasan such, this is a very peculiar case. He's still residing in that house on my land. Kaliram Ragon, who put forward his claim in the Kabang that the portion of land purchased by me was given to him by his father-in-law, Sri Sasan such, from in kind. From 1984 to the last part of 1991, Kaliram Ragon did not put forward his claim over the land. There were two Kabangs held, but in the first Kabang, either myself or my father was not called to attend. In the second Kabang I attended, the Kabang was to be scheduled on the basis of spot verification of disputed land, but the Kabang did not verify disputed land on the spot and give decision abruptly in favor of Kaliram Ragon. Not getting justice from the Kabang, Opagrome made another petition to the Deputy Commissioner praying for holding of Kabang after spot verification, and accordingly, Deputy Commissioner gave order to hold Kabang on spot verification. Accordingly, dates were fixed to be held on 28/193 and 2/2/1993. We attended the Kabang, but Kaliram Ragon was not attended and such decision could not be taken. I had developed the land by planting trees, bamboo, bush fencing, erecting house, and thereby till that I spent around such and such. And paper exhibit 3 is the expenditure shown for that purpose. The land is still in a position and I am enjoying the same. Kaliram Ragon, in support of his claim, did not produce any supporting paper either in the Kabang or in the court to prove his claim. The adjacent plot of land belongs to Kaliram Ragon, which he got from his father-in-law, but my plot of land was never given to him by his father-in-law. That is our case. I want the Honorable Court may please declare right title declaration of ownership and possession to me. The copy of official summons to Kaliram Ragon are filed in the court, which is the paper exhibit 4 and 5. At the time of purchasing, we verified properly that my plot of land did not belong to Kaliram Ragon. The sale deeds, etc. were prepared by Sri Olomdai. When we went to search and verify the land, Sri Olomdai accompanied us. Sri Olomdai also negotiated between my father and Sri Opagrome in respect of selling and purchase of plot in question. The signature of the witnesses were also taken in the sale deed cum agreement. Cross-examination. While the negotiation to purchase the land was going on at that time, I was in college, but on giving me information, I came back to Pasigat for that purpose. On 29/7/1984, I was present at Pasigat. While the land was purchased at that time, Kaliram Ragon was not present at Pasigat. I cannot say where his posting took place at that time. I was not known Kaliram Ragon. It is not a fact that after hearing information of our purchase, Kaliram Ragon wrote a letter to my father. We are denying this. It is not a fact on the plot where I occupied, a man from Tabing clan purchased the land. It is not a fact that a man of Tabing clan left the place, though he purchased, but considering it to be illegal, and for that he left the place. It is not a fact that after hearing the land of others, my father was also surrendered to occupy the plot. While Kaliram was claimed upon his land in a meeting at the time, I was the only person who objected the claim. Besides, Sri Opagrome was also objected to the claim of Kaliram Ragon. I cannot say whether my father served a legal notice to Opagrome through a pleader. I should see the record whether, first of all, the case was given only against Opagrome. I do not have any dispute regarding the date of filing of this suit, as it is a matter of report. This petition was filed on 7/5/93. In that petition, my father clearly stated that if we lose Kabang, for that Opagrome should give us alternative plot. Though father has filed his petition later on after his copy of WS to Opagrome, I have seen the WS of defendant number Sri Opagrome, WS written by Opagrome, i.e. 36, and Sri Opagrome admitted guilt of selling the land to Kaliram Ragon. As per the WS para number 2 of Sri Opagrome, has already stated that he will refund the money. In the WS of Opagrome para number 3, Opagrome has clearly mentioned the name of two owners, i.e. Kaliram Ragon and Srimati Okenrome, wife of late Onyogrome. As per the content of one of the WS dated such and such, I have got no stand on disputed estate. After that, on 19, I got an order from circle officer by directing me to vacate the plot within 20/12/93. The DC Pasigat has given me a so-called notice by directing me to vacate the constructed house on 22/5/95. After getting my reply, the DC Pasigat has only given months of time for vacating the plot. Before expiry, we presume I might not get stay order, but exactly I cannot say when the stay order was given to me. It is not a fact that while I purchased the land from Opagrome, I did not make through inquiry from person who knows about the owner of the land. While we tried to construct the house upon the disputed plot at that time, we have been issued a letter from PN not to obstruct the house. It is not a fact that the land where I am staying is not the land of Sri Opagrome, but of Kaliram Ragon. It is not a fact that I have purchased the land from not purchased the land from the actual owner of the land. It is not a fact that I have not purchased from the actual owner of land, that I am not established by ownership upon the plot. Sri Kaliram Ragan did not disturb us in the initial stage of purchasing the land. It may be due to his remote posting and may be due to lack of information. It is not a fact that I do not have any knowledge about the transaction between my father and Sri Opal Rome. It is not a fact that I can never get my land as own. This is on cross. Now, PW2 is a person, my lord, who was in fact bought the land of Kaliram Ragan, which was actually the land of Kaliram Ragan. Ultimately, he returned it.
To Kaliram,
Yes,
the appellant.
yes. He actually bought that land. The person who sold it to me, his younger brother, sold it to the PW2. This is his deposition. I know Dr. Talom Tai, Sri Opek Rome and Kaliram Ragan. Dr. Taing and the plaintiff purchased a plot of land at village Burbu. I heard that the land was purchased from Opak Rome. I purchased a plot of land from Oi Rome. This is the brother of Opak Rome, which near to some extent upper side and the lower side of the plot land was plaintiff land. In between the two plots of land, there was clear-cut demarcation. What he's saying is there was clear-cut demarcation between the land of the plaintiff, that is me, and the land that he bought. In between these two lands, the demarcation was found to be bamboo fencing. This land was wrongly sold out to me because the land belonged to Kaliram Ragan. He's accepting that. Kabang was held and the dispute was decided. For that reason, I got back my money and handed over the land to Kaliram Ragan.
It's a different land.
This is the land that actually where Kaliram Ragan now resides.
Okay.
This is the land that his father-in-law gave it to. Sri Oni Rome refunded the money to me. The land of plaintiff was under his possession and clear-cut demarcation was there. As there was no dispute between the land of plaintiff under his possession. I belong to Tabing clan. What is clearly saying that the land that I bought was clearly demarcated from the land he bought, which actually belongs to Kaliram Ragan. I purchased land from both the brothers, such as Mai Rome and Mani Rome, that is Oi Rome and Oni Rome. While they sold out to me at the time, it stated the portion which is sold out belonged to them. While I purchased the land at that time, I was not known Kaliram Ragan. In the meeting, I was not known whether his purchase products were given to Kaliram Ragan father-in-law. But I simply came to know that I have been illegally sold. For that, I returned the land. Prior to me, Taing purchased. After that, I purchased the upper plot. I do not remember whether Dr. Taing, the plaintiff, was present at the time of conducting the kabang, which was held between myself and Kaliram Ragan. I do not know whether it was the tricks of the three brothers who captured the land which was given to Kaliram Ragan by his father-in-law. They have divided the land. If I could know the fact earlier, I was not supposed to purchase the land from Oi Rome and Opek Rome. It is not a fact that the southern portion which was lying of my plot, which purchased, was not the land of Dr. Taing. I came to know from Dr. Taing that I purchased the land from Opak Rome, but I cannot say whether Opak Rome is the real owner of plot. I cannot say whether Opak Rome has sold away the land of himself or he has sold away of some other. Next is the PW3. He is not very relevant. He doesn't know. Nobody, in fact, that's why, if your lordship requires, I will give a written argument what they have said. So he is not very, this is my witness, but even then it is, he gives the same as what would give for the.
So three plaintiff witness.
Plaintiff witness.
Three only.
Three only.
Okay. Then this is
116 is DW1, the person who sold it to me. DW2 will read interesting reading.
this the DW1 Opek Rome, who has sold the land to you.
Yes.
He's not disputing.
No, but I think I should read this.
Do you have the relevant one? Anything against you?
No, nothing is against me.
Is he confirming that?
Yes, he's saying that he in fact says that my brother wrongly sold the land of Kaliram Ragan to that Tabing. So I asked him to return to that. But the land that I sold to me, that is the plaintiff, is a different land and it belongs to me. He says that my father told me that he has given him a portion of land, but not all the land. Only the portion that Kaliram Ragan is occupying and where he's staying. That is what he says. Then my lord will come to DW2, Kaliram Ravan. This should take care of everything. This I will read.
DW only two. Both
No,
the
my lord, there are
departments-
so many DWs. All
Okay.
of them,
Okay.
basically
How
hearsay.
many? How many?
There were around 4 DWs and there were additional 4 DWs.
Yeah.
All they say, I will read one of them so that my lord will know what else they have said. All they say is that Kodang Rome told me that he's given a land to Kaliram Ravan. Everybody says, Kodang Rome did not tell me what is the exact area of the land. Everybody says in that matter.
But they were told that.
He has given
land
him
has been given to-
only there, only there. He does not say, I have given all my land in Murbuk to him. He says he has given the land.
So are you saying you are saying that the land which is given to him is still intact?
Yes.
He's having that land only.
Yes, yes. He's staying there.
Same persons.
Yes. My land is very.
The owner,
it makes for,
original owner is the same person.
my lord.
Some person.
The land given to Kaliram Ragon by his father-in-law is intact. He stays there.
Okay.
Other portions have been sold off by his brother-in-law.
Brothers. You purchase it from
His brother-in-law.
brother-in-law. Okay.
So nothing remains there. But Kaliram Ragon's land is there. 119. I am having a case against Sri Opagrome and Dr. Tang regarding a land dispute. The dispute land is situated at Tigramurgu. I purchased the present dispute land from my father-in-law, late Kodang Rome. In the year 1975, I paid rupees 500 to late Kodang Rome in consideration of the present disputed plot. The disputed land is bounded in the north to the land of Tasing Sita. He said he paid 500, but relatives of Kodang Rome says he gave it out of love and affection so that my daughter can stay in Pasigat. He was not from Pasigat. The disputed land is bounded in the north by the land of Tasing Sitang. Western boundary is Ling Road. In the southern side, there is also a Ling Road. In the eastern side, there is the land of Sri Raktam Jabo, Sri Tingolong Borang, and Taniri. When I was given this land, at that time, my father-in-law showed me the boundaries of land. The land which is located on the western side also belonged to late Kodang Rome. Now the portion of land which was kept by my father-in-law has been sold away to different persons. Exactly, I cannot say which portion of land was bigger size, but the boundary of the land from father-in-law to my land was bifurcated through Link Road, actually, it should be. And presently, it has been converted into a metal road. From 1976, I have constructed a house, and up to 1979, I was in that plot. Thereafter, I was posted at Mariang. From Mariang again, I was transferred to Inkyong. At Inkyong, I stayed from 1991 to middle of 1984. Thereafter, I was transferred to Zero up to 98. I stayed at Zero due to demise of my wife and my transfer to Mariang sometime in 1978. I had to go to Mariang, and on posting, by virtue of my prolonged stay there, another place, I could not maintain this house constructed over that land. During the lifetime of my father-in-law, there was a dispute arose in connection with the present disputed land. Once I came down to Pasigat and visited hospital in the year, my father, who was admitted in hospital, told me that I was getting ashamed to see your face, but not that moment has already passed. He stated to me that the plot which was given to me was sold away by Opagrome, present defendant, to Sri Rukpur Rukpo. My father-in-law stated to me that selling of the plot in the eastern side of the road was completely illegal, as the plot which located in the eastern to absolutely belong to you. And for that, my father-in-law exchanged a plot of land to Rukpur Rukbo in the western side of my plot. Now, all these persons have not come before the court as witnesses. In the year 1986, I got an information that my land has been sold away by Sri Opagrome to Tasing Tai. Oirome also sold away part of my land. Onirome also sold a part of my plot. Well, I got this information at that time. My posting place was at Zero. On getting that information, I wrote a letter to Tanyo Siram and Tasing Tai to take back their own money from seller, as the land is belong to me but not them. While I sent letter to them, I kept the copy of my own. Paper Exhibit 1 is the letter which was sent to Tanyo Siram and Tasing Tai. Now this has been wrongly recorded. It has not been exhibited. There is no record. The so-called letter he has purportedly written in 1986, asking us to take back the money. That is not exhibited. Page 120 at the top.
Okay.
After sending the letter, I thought that they would listen to my wording, and for that I was still at zero. In the year 1990, I came back to Pasigat, and there I could see that the purchasers did not listen to me. Since the sellers are my own brother-in-law, and for that I tried to settle the matter amicably. Even I asked them whether I purchased the present dispute from their father or not, and that they agreed that the present disputed land was purchased from their father. Defendant and his brothers always accepted the purchase from their father, but from time and again disturbed me by selling the land to others. And for that, I have kept a receipt from them on writing regarding the purchase of the land, and both the brothers put their respective signatures on the paper. Not exhibited, my lord will kindly make a note of that. This is also not exhibited. The so-called receipt. While the receipt was prepared at the time, many witnesses are there. So far, I remember Taling Tali, Tasing Tali, Mulung Jamo, and Raktem Jamo, and Anden Ragon. None of them came before the court as witnesses, who were present at the time of the writing of the spread, not examined. After that also, I told all my brother-in-laws to settle the matter amicably, but since the matter could not be settled amongst us, for which I made a complaint in the 1991 conducting a kabang on the disputed side. A kabang was held at Pasigat Kabang office. In that kabang, the defendant and his brothers were found mistake, and the land was given to me. Paper Exhibit 2 is the kabang decision which was held on such and such. After settling the matter, already in kabang was again called in the meeting 1992. Paper Exhibit 3 is the kabang decision held on 23/5/92. In that meeting, Sri Opek Ramesh cleared he will give me another plot of land to Tasing Tai. As per the kabang decision of 23/5/1992, the ownership of the land was established in my favor. Accordingly to the kabang decision which was held on 19/12/92, the other purchasers who was at Tabing, they surrendered on hearing the kabang decision. In spite of that kabang decision, the present land in question.
Just 5 minutes. I have some something. That's why I was late for 10 minutes.
Around 9 lines from the bottom. During the lifetime. Page 120. Yes. During the lifetime of the present plaintiff's father, who surrendered the plot again, they started to construct illegally on the plot during the election. Thereafter, I made complaint before Deputy Commissioner, and an order was passed by Deputy Commissioner 1993. Is an order issued DC Pasigat. Accordingly to the order, they have been asked to vacate the land. The DC Pasigat has also passed an order upon Kabang Region Place Exhibit 5 was the order of DC, which was passed on 4/2/1993. This has been set aside, madam. One day, Opagroma came to my house and stating that he did mistake, for which he wants to consult with the lawyer. And for him, I took him to Advocate M. Pertin. The advocate himself requested him for draft an affidavit, and after that affidavit was sworn, paper is an affidavit sworn by such and such. Thereafter, he handed over the affidavit. I was taken to the office at the time of swearing the affidavit, and the concerned magistrate repeatedly read out the content of the affidavit and translated into Assamese. The present plot where the plaintiff has constructed is belong to me. They occupying the land illegally and forcefully. The statement which was stated by Sri Opal stating himself as illiterate is completely false. Actually, I did not know his education qualification, and he read. He was serving as chairman in RWD. The statement by Opagrome in this case are completely false. Now I want relief from this court. The illegal enforcers should be immediately vacated from my land, and I should get my entire own land. Procedural. I read up to class 10. I do not know whether this case is de novo trial or appeal case. I do not know what the governance has done. I did not mention the total area of my land for which my claim is rested upon. I will kindly note this. I did not furnish sale deed, money receipt, agreement, etc. in respect of purchasing this disputed land. Paper Exhibit 1 is a carbon copy. The original is not with me. I cannot remember if I furnished the original copy of Exhibit 1 to the court. I sent the P Exhibit 1 letter by ordinary post. I am not having the registration receipt and acknowledgement due to the Paper Exhibit 1 sent by ordinary post. I got the knowledge of purchasing of DL in 85-86. From 85 till the date of holding Kabang, I did not take any action against the purchaser of DL. It is fact that I did not mention about Sri Rugbo and Sri Siram in my written statement, though I have stated in my examination in chief. It is a fact that Sri Tadang Tabin was possession of portion of where my house existed, but he was never in possession of the DL. When late Kodang Rome expressed his view about the landed property, at that time nobody was present. I have mentioned the boundary today for the entire land, including the disputed land. The undertaken from Rome brothers were not furnished to the court. I am not producing any witness in respect of writing of the undertaking by Sri Rome brothers. On my return from Zero, I tried to settle the matter with Rome brothers, and this thing I did not mention in my written statement. It is not a fact that Openg Rome did not state after conclusion of Kabang that he would give another plot of land instead of DL. I allowed Sri Toning Pertin advocate to reside in the disputed land as permissive possessor, but I did not sell this land to such and such. It is not a fact that the magistrate did not read out the affidavit to Sri Openg Rome. Sri Openg Rome put his signature in the judicial office, but not in the presence of magistrate in his chamber. The plaintiff erected the house in 1992, but not earlier to that. I do not know if the plaintiff had erected house prior to 1992 on DL. In the year 1986, the fencing, planting of bamboo was done by the plaintiff. It is not a fact that a DL was not sold to me by my father-in-law. I thought my letter was accepted by the plaintiff, and with this anticipation, I did not do anything till 1991. It is not a fact that on getting the undertaking in 1990, I got a clue to place my demand for the DL and thus referred the matter to Kabang.
Yes.
I agree that I did not attend the Kabang on 28/1/93 and 2/2/93, fixed by DC Pasial in spite of getting official summons. I thought 2 times Kabang gave decision in my favor, and thus I did not attend third Kabang. I belong to such and such. The approval of the second Kabang was given after date fixed for Kabang. The approval was given on such and such by then DC such and such. My Lord, kindly note the next line. I presume that if I attend the Kabang on 28/1/93 or 2/2/93, and if spot verification is held, the decision might go against me. What is in the last part is the deposition false apart. He has clearly stated the reason now. That would go against me. I think that's enough. Then I do not agree that DL was purchased legally from seller by plaintiff. It is a fact, my Lord, kindly note. It is a fact that I do not know the area of the disputed land. That is what the learned trial court has recorded. I am having no any documents, so it appears that I did not purchase the DL. We have been maintaining status quo as per order of the court. The plaintiff is in possession of DL from 1984. My Lord, kindly note this. The standing trees in between the boundary of my land and the DL was planted by me.
Standing trees.
Between the boundary of my land, his land, appellant's land, and the disputed land was planted by the appellant. There was a prayer made by Opak Rome, the deal one, for holding a kabang at a spot. He clearly says, I did not attend these 2 kabangs because if spot verification is done, that he might lose, it will go against him. And he has clearly now stated the boundary, the trees in the boundary between his land and the disputed land was planted by him.
This could be the reason Mr. Tara has skipped.
That's what I'm trying to say, actually. he has not read his deposition.
At least this court would want to know what was his system there.
That is right. Now the other depositions are, my Lord, there are 8 more. If your Lordship wants, I will read everything.
It's okay.
Or otherwise, I will give in a written argument. I'm just synopsizing what they have said. There, my Lord, in the civil suit, my witnesses will be my friends. It is all like that. His witnesses, everybody has said that Kodang Rome has told me that he has given a portion of land to Kaliram Raman. Accepted. Nobody says what was the actual land, what is the area of the land, what is it bounded by, nobody knows. All hearsay type of evidences. It is exactly like that. All of them. Even my witnesses.
Roman, what Roman?
Opak Rome.
Opak Roman has?
Kodang Rome, the
Kodang Rome has said that?
No. All other witnesses of Kaliram Dragon says that Kodang Rome told him that he has given a plot of land to Kaliram Ragon.
That's all.
Nobody, no, yes, nobody knows.
No
even-
location,
And when the
nothing.
land was given, nobody was there,
location,
no location,
measurement,
nothing,
nothing.
nothing. It is in that manner, all evidences are there. And then precisely the reason that is why the deposition is not being sold.
Have you stated in your chief or cross that that part you just showed that this land given to this defendant number 2
Yes.
is still intact?
That is not exactly been said, but
And
the
it is
DW1, from the DW1, it can be clearly inferred. Because we are saying his plot and our plot is distinct. That we have said.
That's what you are.
At page 110. In fact, the plain itself says north is bounded by Kaliram Ragon. At page 110, just before the cross-examination starts, does not say intact. The adjacent plot of land belongs to Kaliram Ragon, which he got from his father-in-law, but my plot was never given to him by his father-in-law.
Where it is?
At page 110.
Hmm.
1, 2, 3, 4, 5, 6, 7, 10. 10 lines from the cross-examination above, my lord. It starts from the adjacent plot. Yes, my lord got it. 10 lines from the
In the cross.
Yeah, from the cross. Before the cross starts.
Yeah.
Examination in chief. 10 lines from it ends.
The adjacent.
The adjacent plot of land belongs to Kaliram Ragon, which he got from his father-in-law, but my plot of land was never given to him. This clearly infers that
So
he.
his witnesses also says so.
Yes.
Opak Roman has told him, told them that a plot of land was given to
Yes,
him.
that is the, even Opagome admits that he has that plot of land. But my land is distinct. That is what Opagome also says. And the other witnesses, they only say that Kodang Rome has told him, as if Kodang Rome has told everybody in Pasigat that he has given a plot of land to Kaliram. It is in that manner the evidences are. Because I appeared in a trial court also. So I have already written how the depositions have gone. I have already prepared it. I did not submit it today because my learned friend is submitting this and that and all these things as well. So I did not. In fact, I will highlight the portion where he has admitted that he did not attend the Kabang for such reasons and the boundary he has planted. That should suffice, man. Otherwise, around 15 depositions has to be done. And this should take care of it. He's the person who's saying it. And regarding all the technical, the last arguments that my learned friend was making, all that substantiated by nothing, never taken in the regional standard manner. This is civil suit manner. How can he urge a ground he never urged? He's on that. No point going on and on. Nothing is being shown. That is the experience I had for other portions.
Complete. Instead, he wants to reply. Nobody
has heard it. What will he reply?
Nobody has taken note of his submission. What is to be done?
Lordship, I take the instruction.
Just take it instruction. If you want to reply, in fact, how he will reply?
Yes, exactly.
Because no, you have not taken. He said that his junior will take note of his submission.
One of my juniors is here, Lordship.
So he hasn't taken any note of his submission.
I just taking instructions and inform his court.
Nobody was here. At least they could. It's good for the junior lawyer also would have taken note of it. That's the way we learn.
Yes, I take instruction.
You just take it.
Yes.
You just tell him nobody was there. Nobody has recorded the submission of the points submitted by the other party. What sort of reply you would like to give? Just call them. Just call them. Just call them. Unlisted. Yes. Only will call for the city.
Yes, my lord.
Mr. N. Rama.
Yes, my lord.
Then counsel for the applicant. This is an application under section 483 of PNSS 2023. Praying for grant of bail to the accused person Sri Tabagatu in connection with eternal PS case number 133 of 2024 under section 21 within bracket small b bracket close oblique 29 NDPS Act. Call for the scan copy of the case diary. MST the TG landed initial PP. Get this for the state. List
On first, dear Lordship.
First of
on 01
Yep.
first October 2020.
much.
There's a consent
Yes.
at 10%.
Yes,
Consent has arrived.
consented.
Yes.
Okay.
Yes, in discussion, the company offered 9%, but the claimant, respondent said that below 9%, below 10%, he can go. 10% he is agreed.
Okay. To that extent, we will modify.
From 1st January to
We will
today.
go into the merit
Merit need not be.
on the
because
consent,
consent.
consent of the parties. Huh?
Yes, yes.
Heard Mr. Estapit, learned counsel for the appellant.
I'm
No.
not appealing.
Okay.
appellant.
You heard Mr. Udeka, learned counsel for the appellant. And also heard Mr. Estapit, learned counsel appealing for the respondent. Next period. This appeal is directed against the judgment and order, judgment and decree dated 18/01/2023 passed by the civil judge within bracket senior division UPR in money suit number 207 of 2013, whereby the learned civil judge has decreed an amount of rupees 65,67,000. You write in words also, bracket close, with interest at the rate of 6% per annum. And on the decreed amount and rupees, 6% per annum and rupees 10,000 only as a cost of litigation. Next parent. Since the as the parties have agreed and consented to the effect that the interest part, right? The interest of the interest part, interest, the rate of interest of 6% per annum be modified to the extent of 10% per annum from the from 1st January 2013. Yes. To till payment till the final realization of the full and final realization of the decreed amount of rupees 65 lakhs 70,000 67,000. It is the present appeal is disposed of by modifying the judgment and decree dated 18/09/2023. Accordingly, the appellant shall pay the decreed amount with interest at the rate of 10% from 01/01/2023 to 2013 till final full and final realization is made. That's all. Does it make obligation? Yes. In that. Because that the appellant is not facing this grounds. No, it's agreed and consent. Yes. On the the parties have agreed and consented to the effect that so and so. That's all. Well, agreement in respect of the interest, since the rest grounds on merit also have been raised. On that part, some has to be there. In view of the agreement and consensus between the parties, it is needless to observe that the appellant has not pressed the other grounds taken in the appeal. Or else, it is needless to observe that the other grounds taken by appellants is deemed not pressed. No. That will be pressed. The appeal stands. Specific time maybe. What? To make payment. That's already given in the. It's given. So as soon as it will incur the interest on you. Yes. The moment the sooner you make the payment, it will be better for you. Okay. You will not say anything.
But only the decree is modified to the extent it's indicated.
The decree. No, before that, before the last line, you just say decree is modified to the extent indicated on consensus. Yes. Right? Then you just give the rest. Then finally you stands close and dispose of most of it.
Lord, it appears they are not doing
Yes, Lordship.
Yes.
He's not going to reverse the Lordship. Already submitted, Lordship. Already whatever submitted.
Okay.
Lordship may decide.
If you, I'll just give you one more chance, not for argument. You give if you want to give more written submission, we're fixing it tomorrow again. Not for argument.
No, sir.
Would you like to submit more?
Also, that's not, I not take the instruction.
Because I have enough indication, we have given enough indication. Anyway.
Enough hearing is done, Lordship.
Heard Mr. Titi Tara in item
23.
Learned counsel for the appellant, and also heard Mr. Deepang, learned counsel for the respondent number 1, non-APS for respondent number 2. Hearing concluded, judgment reserved. These are for all for us Saturdays and holidays.
These are the typical cases that are going on. But appellant need not argue with it.
Pardon me, Your Honor. Your Honor, in item number 18, there was an interim order.
Huh?
In item number 18, there was an interim order.
18?
Yeah, 18.
What 18?
18, item number 18.
You have taken the consent, the adjournment?
Yes, Your Honor.
Interim order pass, yes.
My Lord, this is an criminal petition under 482. My Lord, this is to set aside the bail order passed on 26/2/2024 by the Court of Session Judge.
Mr. Singh.
My Lord.
Mr. Singh.
Yes, my Lord.
Why don't you join the court physically? It's very difficult via BC.
My Lord, actually I came many a time, but
Where are you
now? My Lord, right now I'm not in Itanagar. Right now I'm in Imphal. Right now my Lord, I came many a time, but I could never, the matter never reached. That's why today I'm just trying from BC. My Lord, am I not audible? Am I not audible to you, my Lord?
It's audible, but it's not compatible, not convenient.
Oh, my Lord. My Lord, I many a times
Anyway,
physically.
Yes, what is the
My Lord,
what is
this is a criminal petition to set aside challenging a bail order passed on 26/2024 that my Lord will find in page 15, my Lord.
15?
My Lord.
15, 1-5.
1-5, my Lord. It's a small petition.
Yes.
My Lord, here, in fact, the charge was under 302, especially, and 341 of IPC. But while granting the bail, my Lord, the parameters of 437 to consider a bail in a heinous crime was not taken into account by the learned trial court, and only into accounts that he has spent about a year and he's 72 years old. That was the observation made by the learned court while giving this bail order. So being aggrieved, the son of the deceased challenged this bail order under 482, my Lord. My Lord, here in this particular case, I have mentioned in my petition also that 3 persons were taken 164 statement under CRPC. My learned, and moreover, the record has been called for, and my learned friend, Ms. Jailiang, will submit the deposition of 164 and deposition of PWs, my Lord. And my Lord, here, the observation made by the trial court is that till that, next page, page 16, upon hearing the learned counsel on the facts and law, I have thoroughly perused the records. Till 14/6/2024, prosecution has examined 3 witnesses. 2 are stated to be family relative of the accused, my Lord. There are 164 statement under 164 CRPC. The statement of these 2 relatives also, even they have affirmed that the accused is the one who has taken that who has murdered the deceased. And my lord, I'll respectfully take my lord to 164 statement and the deposition made by the accused. So only on this observation also, my lord, he could not have been granted bail because it was in an admitted position that he has committed a crime under 302. My lord, the observation that my lord will find, the finding of the trial court, the evidence collected by the investigator and the ocular evidence, if your lordship have found in page 17, the evidence collected by the investigator and the ocular evidence as well as documentary evidence so that the victim died as homicidal death. I have also given due consideration to the grounds laid by as well. His age is 72 years, having permanent residence from so and so, so and so. Now, these are the factors that the trial court has taken into account while granting bail. But this is all totally against the catena of judgment of the Honorable Supreme Court. My lord, I'm on the perversity, illegality of the order passed by the trial court, my lord. And if your lordship is not comfortable with my virtual appearance, my lord, your lordship can fix on Monday and can hear the matter also. Or
why don't you file an cancellation of the bail?
no, my lord.
There's no
My lord, this is an application under 439 and 482, my lord. Under 482 and 39. 439(2) says about that High Court and Court of Session can cancel the bail and can remand, can rearrest the accused. So my application is, my lord, under 439 to cancel the bail and 482.
I won't take much time. Within 10 to 15 minutes, I'll clarify the law position as well as even the fact also, my lord. The fact, my lord, so far the pleading is concerned and so far the material collected is concerned, there's not a single eyewitness who has identified the accused, my lord. And the trial court, while granting the bail, has gone into entire record, my lord. It's on the record, my lord. It's indicated in the order itself, my lord. So far, my lord, the cancellation of the bail is concerned, granted the trial court. The overwhelming, the supervening circumstances, compelling situation has to be established, my lord. It is now well settled proportion of law from very beginning until today, my lord. Latest judgment I have, my lord. And there's a parameter whether the age can be a relevant factor for consideration of the bail, my lord. That is, Honorable Supreme Court said yes. The age is one of the relevant factors for consideration granting bail. But the trial court, my lord, it is well settled. I'll place that and for two.
There may be a relevant factor, but it's not only one.
Yes, yes, my lord.
Only a factor.
Yes, my lord. So that is why other part, my lord, prima facie case, the prima facie is not a case of prima facie case, my lord. There's no, the so far 164 is concerned, it is only mere hearsay statement, my lord. Even if assuming there's 164, itself is not substantive evidence. It is to be corroborated, my lord. 164 statement, it is admitted fact. My learned friend will agree with me. It is not a substantive evidence, my lord. Be that it may be. Even 164 says that there is hearsay evidence. It's not that I have seen it and this has happened. It's not a case. Somebody has told him that this was happened and this was, the fact was narrated by somebody and that is third person is narrating. This is the fact. Even the 164 statement, even although it is not that entire event, it is not applicable in this. And so for eyewitness is concerned, no eyewitness. Only single one, the two eyewitnesses was stated, they have not seen the person who has committed committed the crime. Nobody has said. That's it. And having gone through this aspect,
my lord, may I kindly place the 164 statement and those who has given 164 statement, their deposit has been made. It is in the LCR, my lord.
Every offense, I believe, did not have for every offense need not be eyewitness.
My lord, that is there. Yes. The circumstantial evidence, that is also there. Now, the circumstantial evidence, what says? The chain, the linkage, it has to be in such a way that there's no other conclusion could be drawn except.
That will not go into a stage. Privacy, of course.
Yes, madam. And there's possibilities of interference in the trial, fair trial, my lord. That is also one of the factor, my lord. There's no as such ground made out, even if they are in the criminal petition itself, no such grounds made out, my lord.
I don't find any ground.
My lord, my lord, I beg to submit, my lord. I would like to submit here in a petition under 489 and 439. It is not a circumstance, it is that not primary. It is how the order has been passed without considering the plethora of judgment passed by the Supreme Court, my lord. I've given the list of citation also. It is not that he will abscond or he will flee or he will interfere. It is only the case that in the plethora of decision made by the Supreme Court, my lord, that the severity of the offense, the accusation, and if convicted, the time that he will spend, and more of 437 is very clear regarding that. If he is charged under 302, that is life or death, my lord, bail shall not be granted, my lord. Here, my humble submission is, my lord, in the 164 statement, my lord, two witnesses who has given 164 statement, 164 statement, my lord. My lord, in page number 4 of the compilation which I'm submitting, which my lord will find in the record also, my lord, it is 164 statement, Mr. Takeyaku. My lord, Miss Srimati Takeyaku was examined as a prosecution witness 1, my lord. Takeyaku was examined as who has given 164 statement. She was examined as PW1, my lord. Now, what she said in PW1, my lord, after going to the statement, she is given an PW1, my lord. On that condition, whether this grant of bail was necessary or not, that is the only question that will arise. My lord, I have given the citation also where the Supreme Court has said that reason that particular parameters to grant bail in under 302 has been discussed, my lord. My lord,
I have seen it. You joined the court physically.
My lord, I'll definitely join. Please fix a date. I'll join.
Otherwise, if you want to dispose it, I'm dismissing it. I don't find any ground.
No, I'll join physically. Please fix a date. I'll join it.
Next week.
My lord, the last day is report last day.
Difficult, my lord, if my friend, my lord, agree with my lord, let it be list after vacation, my lord.
After vacation.
My lord, the next evidence is on 8. After vacation, next week I can argue next week.
After break.
After vacation. After puja vacation, right?
My lord, next week is any day that your lordship can kindly accommodate next week.
My lord, let it be on after break, my lord. There will be from their personal difficulties on my side, my lord.
Your friend has some difficulty next week.
Let it be after break.
Any day, my
For
lord.
convenient. After
On the prayer of Mr. M.G. Singh, London Council for the petitioner. List this matter after puja vacation.
Please fix it then, my lord.
Any fixed date? Do you want any fixed date?
My lordship, may kindly fix any date.
You just
My lord, any.
22.
But as soon as early date, my lord, early date.
22, make it 22.
My lord, can it be little?
October, it's holidays up to 28. 21, make it 21. 21.
My lord.
October 21. Miss CAB. CAB, earlier one. Mr. T. Tagum, then council for the, and Mr. MSTG, London additional PP for the state, and Mr. T. Tagum, London council for the respond number 2.
Yes, my lord.
Are present.
21.
Aula is not.